so much for making the time. Thank you so much to the organizers for having all of us here. This panel is about technology rights, digital freedoms, and how technology intersects and interacts with the Constitution. And I don't think any of the panelists need any introduction, but Mr. Manu Kulkarni, Ms. Vrinda Bhandari, and Mr. Apar Gupta are here. They're all experts in their respective fields, and today we hope to learn from them what exactly does it mean for new technologies to come up in a traditional constitutional law doctrine setting, and how do the current doctrines of constitutional law apply to evolving technologies. We'll try and touch upon a few aspects: privacy, surveillance, digital content, and the likes. So without any further ado, I would first invite Vrinda to just give us a brief overview of the number of ways in which technology can intersect with the Constitution, and how many issues, broadly speaking, we should be thinking about while thinking about technology and the Constitution. Vrinda.
Thanks a lot. Very loud. Thanks a lot, Shrutanjay, and I'm really excited to be here. I was actually supposed to come, I think, for the first or the second edition, and I couldn't come that time. Nice to I just want to speak very briefly about how tech and okay. I'd also like this for this to be more of a discussion. So after we all speak, I mean, I'd love to actually hear more questions from all of you. So just a very brief background about myself. My name is Vrinda Bhandari, and I'm a lawyer in Delhi. So I'm both a practicing advocate in the High Court, and I'm an AOR in the Supreme Court. And I've done a lot of litigation, which involves tech constitution rights. So whether it's Aadhaar or then with Internet Freedom Foundation, where I'm an off counsel, we've done a lot of challenges, whether, fact check unit, surveillance challenges, Pegasus, internet shutdowns, all of those things. So would love to speak about all of those aspects. Now, just to kind of ground this, what I want to explain is that we have to understand that obviously when the Constitution was drafted, the framers didn't really have this idea of tech as being a big part of the Constitution or something through which state power mediated itself. The discussion at minimum was about the right to secrecy of correspondence. And even then, Aladi Krishnaswamy Iyer and a bunch of other people were P.N. Rao were very opposed to introducing this as a fundamental right. And they looked at it more from a criminal justice angle, that we don't want to impede the power of the state in a criminal prosecution. So technology is something today which has changed a lot. And the biggest impact, I think, it is about how it talks about state power. So where I'm interested in the intersection of tech and constitution is to see how state power uses technology and then in a way affects our lives. And this, I think, can be broadly discussed in 4 ways. So the first is the relationship between technology and privacy. So like I said, the Constitution doesn't have a right to privacy. It's something that has come after Puttaswamy. The second is technology and the criminal justice system. The third is technology and equality, where I think Aadhaar is a really good example of the disproportionate effects of technology, or how technology doesn't impact all of us in equal ways. And the fourth is sort of tech and free speech. So this is all the debate that is happening in terms of intermediary liability, fact check units, blocking powers of the Constitution. So maybe those aspects which you and I would interact with more often than not when we talk about tech rights. So just coming very briefly to tech and privacy, I think the one thing you may all have heard, if nothing else, is that the whole right to privacy discourse started from a Warren and Brandeis article of 1890 in the Harvard Law Review, which is cited even in Puttaswamy. But very interestingly, there's now a lot of literature, and Rahul Mathan has written about it, and there's a bunch of HLR pieces, etc., which talk about what was the technology at that time that they were afraid of. And it's effectively what it was that Warren's brother was gay. And so he was concerned, and this is the time when portable cameras were the newest technology and yellow journalism. So, tabloids were the latest technology. And so that was the loss of privacy that people were experiencing. So his wife, because they were, socialites in America. And so his wife was often the subject of tabloid journalism, and his brother was gay, which at that time was criminal. So he sort of wrote this right to be left alone and why it was important. So, also what is technology? At that time, it was portable cameras, which were the newest thing. And today, what we think of technology is obviously drones, facial recognition, CCTV cameras. So the mode through which technology, the technology has changed, but the concerns of privacy sort of remain. And here, what I'd just like you to think about very briefly is, the privacy harms of surveillance. And we have always had surveillance in the Constitution, in practice. And so to some extent, there's been law since Khadak Singh. It's just earlier, it was physical surveillance. So it was, house visits, night visits, policemen physically following you. And what technology, and, the court has then had a long line of litigation from Khadak Singh to Malkani, Gobind, about different aspects of technology till PUCL, which was telephone tapping. And what technology does, and this is articulated really well in a Supreme Court judgment in the US called US versus Jones, where both Sonia Sotomayor and Justice Alito talk about how technology has changed surveillance is by effectively reducing the friction for surveillance. So what are the traditional constraints of surveillance? They're actually physical resources. So you can only have a police officer tailing 2 people, right? But what technology does, whether it's CCTV cameras, whether it's GPS monitoring, is it allows me to tap everybody. If I just put a GPS sensor on your car, I will get a very detailed profile of where you're going, who you're meeting. And through that, I can create a very good profile, right? I know which doctors you're visiting, who are the people you're meeting. So what technology does is it reduces the friction of surveillance. And that is why today surveillance has just become easier, which is why I think we really need to talk a lot more about the defense in terms of, what are our constitutional rights against surveillance. Now, the legal and surveillance also, it's important to think about surveillance both from a targeted surveillance perspective and then a mass surveillance perspective. And so when you talk about targeted surveillance, that is what traditionally used to be Section 69 of the IT Act and the telegraph rules and the interception rules, sorry, and Rule 419A of the telegraph rules. And that is that framework, and even all the subsequent frameworks under the Telecommunications Act rely in some senses on the executive authorizing an action if they believe it's in the interest of national security or public order, which are very low thresholds. And once that is exercised, there is then a review committee that is constituted, which is a 3-member executive review committee. And the constitutionality of this framework, to some extent, was upheld by PUCL, where there was an argument that was made that we need judicial oversight over surveillance action. And the court didn't really go into it. They said that's not needed. And so one of the challenges that we have put in the court, for IFF, in fact, IFF is a petitioner in that case, is to say that after the Aadhaar judgment, there is a recognition, whether it's the proportionality test or it is even in the recognition of the importance of judicial oversight. Judicial oversight of surveillance action is really important. And the current framework, where there is no judicial oversight of surveillance action, is unconstitutional for the reason that the only data we have is, I think, of 2011, which is 7,500 to 9,000 orders, are issued every month. And the review committee meets once every 2 months. So you're talking about, 18,000 orders. This is the data of 2011. The government has refused to give any further data. They reject all the RTI requests. You're talking about them actually overseeing these minutes and saying, oh, this action was legal, this action was illegal. That's obviously not possible. So I just wanted to flag this. I have written a piece about this in detail on the need for judicial oversight of surveillance action and why the current statutory framework is unconstitutional. So that's on targeted surveillance. Very quickly, I wanted to just touch upon mass surveillance to say that there have been these mass surveillance frameworks, such as the centralized monitoring system, NETRA, which use dragnet surveillance frameworks. But to me, I think the biggest challenge that we have when it comes to mass surveillance today is CCTV cameras and facial recognition. And that really is where the debate in our constitution should also go. How does the proportionality framework apply when we talk about CCTV cameras or facial recognition? Because there is no law in place currently authorizing it. Interestingly, in England, there's a very famous judgment where they struck down the use of the Southwest Police. This is R versus Edwards, where they struck down the use of the police's, use of surveillance. And this is despite the UK having, there were some local laws, there was a data protection law in place, and there was a surveillance code of practice. And even then, they said the law is not specific enough to say who you're looking to target or why you're looking to target them. So I think it would be interesting to talk about the analysis of proportionality framework. So whether there is a law in place, whether there is any procedural safeguards, is this the least restrictive means necessary? Because when you talk about the privacy harm, it is a chilling effect. We know that drones are used to target who goes to a protest. It is absolutely my legal right to exercise my right to free speech and to go to a protest, right? As long as I'm not encouraging any violence. But if I know I'm under surveillance, there is a lack of trust in government because the government has the power to control all of us at the end of the day. And so there is a chilling effect that does get into play when we do have automated facial recognition. Where is this data being stored? Is it being shared with other law enforcement agencies? Is it being deleted after every year? Is it being deleted after 2 years? Is it kept indefinitely? Can you then track my movements across? And we're seeing the income tax bill is actually talking about going into your digital social life. So surveillance can happen through very different ways, and it's not just like the traditional tools of surveillance. So this very briefly is how I think privacy harms interact with the Constitution and with surveillance. The second aspect that I want to just talk about is technology and criminal law. And this is where I really want to speak about the search and seizure of digital devices. When we talk, you've all seen Karthi Kalu, physical evidence, you can be compelled to give your fingerprints or your blood sample. What happens when it's your mobile phone? What happens? Can you be asked to give your OTP, to give your passcode to unlock the phone? Because the phone actually does contain a lot more information about ourselves to some extent than even just the physical evidence. And there is a lot of questions about whether this is compulsion or not. In fact, Abhinav Sekhri has written a great piece about this, which you can read as well. And we've also now filed a litigation, which is pending in the Supreme Court for IFF, where we've talked about the need for guidelines to regulate search and seizure when it comes to criminal law, for the reason that the thing I want you to think about is, and this is a practical advice if a client comes to me saying, police has asked me for a phone. Now, the practical advice may sometimes be, look, give it because your bail may be conditional on it. They say you're not cooperating, right? This is non-cooperation. They're not cooperating with the investigation. They're not giving their phone. But if you do actually give your phone, there are a lot of things in my phone that I don't want the police to see. Once I give my phone, there is no way for me to say, you will only look at this aspect of my chat. So suppose I'm an accused, who's been accused in, say, an NDPS case. So they want to see, oh, who's your drug dealer? Let's look at those conversations. But while looking at those chats, they can look at 5 other conversations, which may have nothing to do at all with the case in question. But I'm still being compelled to give it. And there is a loss of privacy. And there's a lot of feminist discourse about also the loss of bodily integrity. And women may especially feel this more. There are photos on my phone that I may not want anybody to see. And it's not that they're legal or illegal, but it may be, I'm in a sports bra. This is just a photo that I've taken for myself. I don't want to give this to the police. So there is also loss of bodily integrity, which people can face when we do give up our phones. So a practical level, sometimes you may just advise your client, look, give it because it's not worth it. But there are serious questions because the law does not envisage this. The search and seizure provisions currently do not talk about digital evidence, and there are no real safeguards. And so all we end up doing is we, go to the court and say, give the phone back, please, take a clone of the whole thing. But these are, I think, important questions to talk about because the right against compelled self-incrimination really does come into play. And I think there can be a good argument to be made that this is distinct from the jurisprudence in Karthi Kalu, that will not really apply. So that's in some senses when we talk about search and seizure and how it would interact with criminal law. The other place where tech does interact with criminal law is Pegasus, for instance. So that's a hacking of your phone, right? So that is the government, whatever the reason is. I may be the worst person in the world. I may be the biggest dissident, the biggest activist, most critical of government. The law currently does not permit the government to take over my phone through Pegasus. You can seize it. You can send me a Section 91 CRPC notice. You can take my phone in a criminal investigation and seize it, but you cannot hack it because that even under the IT Act, there is no exception for national security, which says that hacking is permissible if it deals with criminals or if it deals with somebody who's violating national security. So that is really where I would think about the intersection of tech and criminal law. Very briefly, then moving to tech and equality. And this is the idea that tech can both entrench divisions in society or mitigate them. And usually from the socioeconomic background that most people will be here, tech will probably be an enabler. And just giving my own perspective from the Aadhaar dispute, what I saw is most people, so most upper middle class people were very much in favor of Aadhaar. Yes, it's really good. All these privacy concerns, they're not that important. And then when there was, maybe you guys were very young when this happened, but there was bank linking and mobile linking. And a lot of people, if they had a middle name, which sometimes had dot, if you had South Indian names, which, didn't always recognize, people like upper middle class people started having problems with OTP linking. And they were like, oh, this is so problematic. But what we never thought about is how does equality and tech play out in a village in Rajasthan, when you have to go and access your entire subsidy is based on seeding. So, lots of parts of the technology have to work. Your name has to be entered correctly. Your numbers have to be seeded correctly. The biometrics have to work. So if you're manual labor, your fingerprints may wear off. You may have disease, like just as you age, your fingerprints also become coarser if you do manual work rather than our fingerprints, which are never chipped. So, you need the POS machine to work. There has to be electricity. There has to be internet connection. There were so many reports of exclusion. And the court just sort of upheld, ignored all those by saying, oh, the government has said that it's fine. Nobody will actually be excluded if there is any problem with this Aadhaar seeding. And again, this ignores the social reality that tomorrow, if I'm at the POS machine, like the point of service machine, and the guy says, ma'am, it's not getting linked, I'm not going to say first, nobody's going to know there is a government guideline. The petty corruption happens at that level. You say, look, I need my 5 kg rice, so tell me what I should do because I need to get that. So the idea that tech is going to solve all this doesn't work. And Aadhaar was promised to us as this one ID, right? But then we still have DigiYatra. That's a new app. You still have the Apar ID, which is being used for students in schools. So it's also this idea that this one app and this one ID to save them all doesn't really work. And so we have to really think about how tech works for people who are not like us. And this another just briefly to talk about tech and exclusion, if you think about girls in general or the idea of gendering surveillance. So in a lot of villages, especially in North India, the access to phones of unmarried girls is heavily restricted, right? So India is mobile first country, but there's a problem with digital literacy, but also the access to phones of many girls is restricted that, oh, she'll talk to boys, she'll do something that's not, correct. She may have, it'll be bad for the shame of our family. And so you see women who are then getting excluded or their phones are really surveilled and their access to phones or what they're talking about. And there is a loss of privacy. So the idea that privacy is an elitist concern is not borne out even in practice. And then just finally, I wanted to talk about tech and free speech. And I'm going to try and end it because I would like us to have a discussion as well. This is the idea of regulating online speech, right? So we've always had protections under 19(1)(a). In Anuradha Bhasin, the court doesn't recognize the right to internet access. And we can talk about what the costs and the pros and cons of that are. But it does recognize that I have a right to speak freely online. And how is the government then curtailing that? So that then is when you see all the regulatory regime that comes up with intermediary liability, which comes up with the blocking of content. And, and maybe Manu will be able to speak about it, but when you have a judgment in the Karnataka High Court that then says that, oh, blocking of user accounts is completely permissible, you're not just saying only illegal content, but even lawful content. A tweet that I may have posted, which is completely lawful, is also getting deleted. Any future content that I might post is also getting deleted. So when you exercise the rights of blocking to block entire web pages or websites and you get them down or entire accounts, there is a real free speech aspect. When you talk about intermediary liability, so you have the fact check unit case where you've seen the Bombay High Court has struck down the government's amendment with respect to fake, false, or misleading. But then other aspects of the IT amendment are still under challenge. And again, there you have to think about what is a regime where, yes, you have safe harbor for intermediaries, but at the same time, if the law is nudging intermediaries to regulate their own content, it results in what is called collateral censorship. So the government is effectively passing the buck on the censorship from themselves to the intermediary. So Jack Balkin talks about this really well about what is collateral censorship in the context of intermediary liability. And so I think there's a lot to be spoken about when we talk about intermediary liability, and also this new, after this whole Ranveer Alabadia controversy, to say that the government is trying to get the broadcasting bill to come in. And that's interesting because decency and morality is not a ground for blocking content. Decency and morality is brought in through the intermediary liability due diligence framework. And so do we really want a case, You may not like the speech. It's highly offensive. Is it illegal? Do we really need to use state power to go after something that we don't like? I mean, that's where those are the constitutional intersections that we need to think of. And then just finally, we talk about the internet being a democratizing idea and a marketplace of ideas. What happens when you shut down access to the internet? Again, this is not something that you or I may have faced, but internet shutdown is a real problem in India. For the 6 years in a row, we have been the leader in internet shutdowns, not something we would like to be leaders in. Jammu and Kashmir has the most number of shutdowns. Rajasthan, surprisingly, is the state with the highest number of shutdowns, often for exams, as if it's going to stop preventing cheating in exams. Manipur last year saw sustained shutdown. And there's a lot to be said about the shutdown framework, whether it's proportionate. Is a complete shutdown constitutional or not? Does it really stop misinformation, or actually can it result in more misinformation because there's a lack of information that's just existing in practice? And then if we get time later on, maybe we can talk about some of the practical constraints in actually initiating litigation, challenging shutdown. Like, what are some of the practical issues we face? But I just wanted to maybe start with this, hopefully not very long introduction. Thank you.
Thanks very much, Brinda, for that very exhaustive understanding of how tech can interact with the Constitution. And now that we have that overview, I think it's a good time to turn to Mr. Kulkarni now to understand what exactly are the modern challenges we face in terms of the IT Act, and how exactly did we get here? It is one thing to say that, today we are standing at a place where anything gets blocked, etc., etc. But there was a trajectory that history took, and there's a reason why it ended up here. And over to you, sir.
It's lovely to be here. Thank you very much. Now, before we start, I want us to go back to, say, the 1990s, when internet, in some sense, began to be available commercially. What did one think was freedom on the internet? What did people imagine was freedom on the internet? Did we think it was going to be a very different sort of world where we would have, in some sense, a supranational connectivity between people, where our freedoms were not determined by jurisdictions and by borders? That was the dream, by the way. So let me just show you a couple of slides and then come back to reality fairly quickly thereafter. Next. Okay. All right, let's just see this. Let's pause for a moment to read. So, very soon, this ceased to be reality. Very soon, the internet was designed. So in the early days of the internet, people were worried about the design of the internet. And those worries and fears are not irrational. Now, we have the example of two kinds of designs. The first, of course, is the design that we experience here, and to a large extent, the design of the internet that we enjoy in comparison to what our neighbors have, where by design, by default, the internet is meant to be a surveillance tool. So in terms of information on the internet, what is it that we are truly talking about when we say freedom? We had books, we had press. What is it that we have very differently today? What we have very differently today is the ability to interact with one another seamlessly. it is that freedom. For example, I'd write a letter to the editor in a newspaper. The editor could publish it, the editor could edit it. Today, that censorship is not there. I am free to speak. Now, what is the law that enabled this freedom? And how an incremental attack on that law will take away this freedom? The freedom that we are so used to now. That is what I'll try to bring about. So, very briefly, what happened in the early decades? Till about 2000 and 2000 to 2010, the law said I should enable technology. I should make sure people can function, intermediaries are free, that electronic records are treated similarly to paper. So that was a very benign decade. 10 to 20 was all right. Let's see what happens in the decade of 2020s. Step by step, the law says now these freedoms have to be clipped. Of course, some of this is laudable. For example, what was done on the consumer protection side. A small consumer is to be protected, but the others are more ominous. Vrinda was saying one app or one ID to save them all. It sounded very ominous to me. It sounded like one ring to rule them all. So, is that where we are heading to? Okay, there are some problems. If we say there are no problems on the internet, we'd be lying. We'd be in a fool's paradise. There are people getting scammed day in and day out. Therefore, who is to answer those? Of course, the legislature is expected to answer those. But what are the answers that we are finding? I am afraid the answers that we are finding are much worse. The cure is much worse than the disease. First, the problem of misinformation has been there all around. Mark Twain said what he said well before internet was around. So therefore, to say I'm here to tackle misinformation, I'm here to present a version of facts is as meaningless as it can get. What is really done? What are the kind of powers today that are being exercised? Interception and monitoring surveillance has been spoken about. Let me talk about blocking and how blocking of information, withholding of information operates on the internet. The first striking feature that I see is withholding of information is not user-centric. The law is not framed to be user-centric. The law is not framed to be, in technical terms, originator-centric. The law is framed to catch hold of the intermediary or the messenger. Why is that so? Let's think for a moment about the design of the law, because then the control is far greater. A simple measure of blocking somebody's account. Let me give a real life example. Assume I write an obscene book, which is obscene in the law as it stands today. What happens? The author is not banned. The book is forfeited. What happens when an account is blocked? The author is off. Of course, the author can create a new identity. The new identity will be blocked again. And while I may not be able to take examples, I've been a lawyer for these intermediaries for 15 years. So I know what I'm saying. So if authors are repeatedly banned, then the author has no space. And that's not the only problem. There are authors speaking on various media on the internet who have a considerable following. One fine morning, the author is not available anymore. The following falls. So, the exercise of free speech, both in terms of the speaker and the recipient of information, that is the kind of blocking that is possible. How is it all of this done? There are two provisions. There is one 69A and then there is 79. What does 69A say? See, by the way, constitutional validity of 69A is upheld by the Supreme Court. But on what grounds? Supreme Court says, see, look, there are very narrowly tailored provisions. There is a review. There is a writ petition to the High Court. And therefore, withholding of this information is all right. That is what the Supreme Court says. The interesting feature of 69A, it does not mention the author of the information anywhere. It only targets the intermediary. If information is not blocked, it is the intermediary who faces the music. So by design, the law will keep, although courts have made incremental advances, by design, the law is keeping the author out, which means suddenly a third party is expected to take up the battle on behalf of the author. So therefore, the design of the law, no, when Lawrence Lessig in early 1990s spoke about the design of the internet, you see the reflections here. What happens in 69A and what are the problems that I see? First, authors are prohibited. Two, they may or may not be heard. Three, quite often, if I have 100 posts and if 5 of them are taken down, I perhaps will neither have the wherewithal nor the gumption to go to a court. Let's simply do a statistic. How many challenges have we seen under 69A? The law has been on the statute book for 15 years. I don't think we have seen 150 challenges, which shows, therefore, that this model is working effectively. And what we don't know is what we don't know. That is the kind of information that simply ceases to exist. We don't know how vast that is. Now, that's about 69A and its focus. There is another provision, 79, which protects intermediaries. Why is that protection necessary? That protection is necessary because, let's come back to 69. The target of information blocking is not really the originator or the author of the information. And therefore, the intermediary comes to be protected. But what's happening incrementally is even this freedom is being clipped, which means what? People who are in some sense just the media, people who simply carry the message, are also told you will become responsible if you don't act on an information. So that's where the regime is moving. As a constitutional issue, India has come very far away from the rule of locus standi. Perhaps no other country in the world allows a public interest litigation like we do. But still, on the private side, standing is a big point. But in this day and age, as a constitutional issue, can we afford to look at standing the way we have? If the design of the law is the author is usually, time has shown, is usually not able to come to the court and make his or her case, then should somebody else be allowed to make that case? Well, this is the rule of standing. That is, a person whose right is violated alone should be allowed to agitate the violation of that right. Now imagine a hospital from where medical records are summoned. Today, can we say the hospital cannot speak of privacy of its patients? And what happens by this rule of standing or locus standi is many patients may simply never end up in court, which means if there were a breach of law, that breach would simply go unnoticed, not just unquestioned. I would never know, right, what information of mine has been seen and by how many people. It is for perhaps this reason that locus and standing are a big issue, that some vigilance on the part of the citizenry becomes important. The second is I want to speak about this as a lawyer. All right, let's understand there are certain things that the law needs to regulate. We can't possibly say the law need not regulate anything. But what is the law trying? What is the existing law? And why is it that the legal regime is faltering? Simply as a lawyer, if I have to go to the text of the law in many cases simply does not permit curbs on information. The tensile strength of the words employed in the law don't permit many of the interpretations that currently hold the field. What's the remedy? The remedy is not to stretch the existing law. The remedy is to make law afresh. And usually when law is made afresh, it is open to challenges. Courts will see whether the encroachment is too much the courts will then water down the law so as to keep it in line with constitutional freedoms, or at least that's the expectation. And that's what happened in Shreya Singhal, by the way. By stretching the law as it is, by making, so how is that being done today? Rules are being made from 2021. The rules, if one were to look at it Puritan as a lawyer, the rules don't find support from the statute. There is no policy guidance in the statute. The rules then cover a vast field which is not imagined in the statute at all. And then what happens? The rule making authority is free to tinker with the rules every now and then. Little by little, stealthily, freedoms are encroached. And that happens as a lawyer to me because the framework is not clear, and in a very reactive manner, the framework is sought to be tinkered. And when the framework is sought to be tinkered, all of us know the person who is tinkering the framework will want to have as much control as one can. It's perhaps true of all of us here also, that if we were in charge of the framework, we'd want to exercise as much control as we can. Much as we believe we are not that kind of people, most of us usually are. So therefore, it's not about the intent of the people, it's about the written letter of the law. It's the written letter of the law that has to provide clarity, that therefore protects us from the vicissitudes of who is in power, or for that matter, who is interpreting the law. It is only when the framework is so well made that freedoms can be exercised. Now, let me conclude by speaking in 1 minute about things that were imagined at the beginning when internet came about and things that are taking shape today. What was imagined was a world without borders. With cryptocurrency, to a certain extent, it's a reality because there is no central, or there is no bank or a government behind cryptocurrency. I am not saying for a moment that it's necessarily a safe thing, but that's the reality we live in today. Today, there are adjudicatory, and this matter came before the Supreme Court in 2019 or 21. The Supreme Court was told and records the fact that the creator of one particular kind of cryptocurrency, nobody knows who that person is. Now, what's the strength of the law? To know who the creator is so that liability can be fastened. That's not there. And yet it's valid today in many parts of the world. So therefore, as time goes by, we are moving towards a future where, to a certain extent, national laws will cease to be as meaningful as we think they are. The second is courts. There are, you go to the internet, you'll find all kinds of courts. They're enabled by blockchain technology. You have a contractual dispute. You don't know who the judge is. It's not faceless adjudication. You don't know what legal system one applies, but people seem to be happy. So then the second phenomena, and I think it is in this decade that these will get tested in constitutional courts, is, are people bound by such decisions? Are people going to be bound by those decisions? Decisions that don't have the backing of a legal system. Let's forget judges in a manner known to law. There is no law. Somebody is simply going to decide on the basis of paper. But if that's the second question. Third, the last issue that I think will come about in this decade is an expansion of the concept of state. In my view, that is quite unnecessary, but that's what I see today, day in and day out. Private actors are sought to be brought increasingly within the definition of state, so that there is a backhanded restriction on freedom. The backhanded restriction comes because suddenly one is called upon to explain decisions, and a requirement to explain decisions usually means a lessening of freedom. So these are the issues that I think we will see in this decade. Long story short, there was some talk about a new law, a new act being drafted, a Digital India bill. There were consultations. Until and unless we have a clear framework, a framework that can be tested before a court, as I see it, there is incremental encroachment of freedoms. That encroachment is not easily discernible, but that's happening year after year. Maybe there is some cause for amendment. One has to be fair. Maybe there are some problems that need to be addressed, but I think the prevention is worse than the disease. Thank you.
Thank you so much, Mr. Kulkarni. I think that sets us in a very good position to now invite Mr. Gupta also, uh, especially after learning that the law as it stands today focuses more on the intermediary rather than the user who creates the content. And in this context, it becomes interesting to ask about the recent litigation that has happened around the space of digital content. One of which is mentioned in the flyer for this event, which is the Kunal Kamra litigation before the Bombay High Court. And I want to specifically ask Mr. Apar Gupta as to what he makes of the government's attempts to regulate fake news and misinformation, especially when it happens over the digital medium, which is an entirely new scale. And as Mr. Kulkarni pointed out, it's a new way of doing things that perhaps has not been tested before. So, sir, what do you make of the government's attempts?
Thank you so much, everyone, and apologies for not being there in person. I thought I could take this liberty after being in person for two earlier occasions when Courts and Constitution was organized. My colleague from Internet Freedom Foundation, Vrinda, happens to be there, who led and worked on this petition for Association for Indian Magazines, and we were also supporting Kunal Kamra as an organization in some parts of the drafting which were conducted. So I would invite all of you, in case you are in case you're interested in knowing what all steps towards that judgment, and there were several that included also approaching the Supreme Court when there was concern that the government would notify due to the absence of an interim order which would stay the constitution of a fact check unit under the ID rules. How was that achieved? So, just towards a little bit more of the practical aspects, she may like to take it up in conversation with all of you. Also heard what Manu said, and that's a very useful outline of first putting us into the past. Where do we think our ideas of freedom emerged from when we first experienced the internet, at least for us older millennials? So when the internet was commercially launched on, I think, August 15th, 1995, and what we saw in the 10 years which were there till about 2005, 2008, 2010 even, I would say, were these conflicts which were emerging on issues of censorship, openness, as well as government surveillance, which were just foundational at that point in time. And I think we are also seeing a similar churn in terms of where we stand in terms of artificial intelligence regulation today. And given that's also an issue of interest, so Achanya, I'll just use that as an illustration of where we are today and why do we also get these laws sometimes. Because a large part of the work of IFF is also deriving from how these laws are made, which means that quite often these are not parliamentary enactments. These are government policy documents or executive notifications which are put to public consultation, because it is often reasoned that it takes a high amount of time as well as administrative friction to get a parliamentary enactment passed or amended. So what we have seen just in terms of artificial intelligence have been a series of reports which have been issued by different government institutions. Principally amongst them is the Niti Aayog and the Ministry of Electronics and Information Technology. Now, the most recent consultation which has been organized has been on a report on AI governance guidelines development. And if you look at it, that will reflect some of the themes which have been in discussion by the other panelists. Firstly, if you look at the consultation document, there is a there is a repeated reference, and this is about governance. This entire consultation paper is about governance. So if you look at the consultation paper itself, there is no reference to the Constitution of India. As much as the consultation paper talks about administrative units, social concerns which emerge, as well as what are the laws which are there on the statute books and whether they need to be amended. So, from a prism of constitutionalism, in as much as we see issues which emerge, which are, let's say, the deployment of facial recognition technologies, which has been constitutionally challenged in the High Court in Hyderabad. Or if you look at how discrimination may be visited on people, which through Aadhaar or other biometric technologies, whether they're entitled to their rations on the condition that they can establish their identity. All of those by itself, I think so, point towards emergent and existing constitutional issues which are not even within the contemplation of the policymaker. So it is not part of the government's thinking. So what frameworks does it rely on? And this is to also look at when it talks about governance, where is that governance coming from? So these are principles which are being derived from OECD, etc. And if you look at the principles themselves, they may match our constitutional requirements. For instance, it says that when any kind of artificial intelligence is being deployed in the public sector, especially which has any kind of impact, it should be done with transparency. However, then there is no mention of the Right to Information Act, right? Which is a much most tangible way how to ensure that, for instance, government tendering processes, the deployment of artificial intelligence, the audit processes, the training data which is collected, etc., is also open for scrutiny either by experts or by the general public who may be interfacing with these technologies. So I would say that the theme of technology quite often overtaking law is not a complete truth, in as much that we are also permitting technology through certain non-legal policy documents, or just trying to box that in quite often within what exists within a statute, without actually looking at its impacts and looking how we can possibly make it more consistent with the constitutional requirements which are present there. So there is a IFF response to the consultation paper. It's on the Internet Freedom website, and that may substantiate where does this concern emerge from. The second part is that quite often when these rules are being made, for instance, even the fact checking amendment which was made, these kind of rules, even if when they are put to public consultation, the public consultation process itself does not follow the pre-legislative consultation policy. And thereby, quite often when you're filing comments today, those comments are not made public. They are held in a fiduciary capacity, which reduces the ability of people to quite often point out not only the errors, but also object on a very principle basis what is proposed in a draft rule or in a draft policy. And this is what results quite often in the exercise of executive power, where the policymaker or the government authority can claim they conducted a public consultation. They did do it transparently. They quite often states this before courts. However, a meaningful consultation does not really exist, and there is a lack of transparency as to what has shaped those rules and why they have been shaped. Right now, let me just come to fake news and deliberate falsehoods. And this has been listed in some detail in a series of questions by Srotanya towards me. And the first is, does Article 19(1)(a) protect deliberate falsehoods? And the second one is, if yes, what grounds under Article 19(2) are available to the state to curb fake news? So here, I think so it's important for us to first understand the phrase fake news itself, which is sometimes a very evocative monolith used to describe this decreasing trust in media, or not only journalism but media much more in general. And if you look at it in terms of putting some scrutiny on that phrase, it may proceed from something which is a mere inaccuracy in a statement to something which may proceed towards domains which are tied to not only the falsehood but attached to a form of harm which is recognized in law, such as defamation, online harassment or something which touches upon hate speech, right? Now, while a false statement may seem like a terrible thing to do, we all do it as well. Inaccuracy by itself is legally tolerable, and it's an exercise of free speech and may even serve important private and public functions, such as conveyed by the phrase a white lie, right? Think about it a little differently, right? And lies in personal conversations sometimes prevent embarrassment, safeguard privacy. They may shield our loved ones from hurtful information. In the context of public statements, there may be forms of exaggerations which may be called lies, such as parodies, skits, satire, which often skirt between fact, fiction, and opinion. And for journalists, also, quite often honest errors in reports are sometimes inherent when you have a lack of transparency or the ability to get public records, especially in societies such as ours, where the right to information law is continuously undermined and there's a culture of secrecy. Now, the propensity for inaccuracy in good faith increases with the growth also of social media platforms, which affords millions of us the ability to broadcast to large audiences with considerable ease and speed. And this is quite often what is cited as the reason there needs to be regulation on fake news. And here, I think it's also useful for us again to go back to Shreya Singhal, where the government's argument for the retention of Section 66A was that the constitutional requirements for legislation and Article 19.2 need to be relaxed in favor of 66A and the vague phrases which would criminalize conduct under Section 66A due to the speed and the spread of information as it travels online. While the Supreme Court said that void for vagueness as a constitutional doctrine would still be applicable to 66A, why it struck it down, it said that if there are crimes which uniquely emerge from this kind of from any kind of digital communications which are unique to digital communications and obey articles 14, 19, 21, you can kind of make that law. So it is not inaccuracy, it is the successive, it's the second order harm, I would say, which is much more important. And even here, when we look at fake news and people who have worked on it for a long period of time, like Claire Waddell, who's at First Draft, which is the Harvard Kennedy School of Government, she says that there is a gradation of fake news which may come from things which are inaccuracies to deliberate misinformation, and they need to be tied to existing statutes and harms quite often. And here, I think so, we already have so many laws where quite often where inaccuracy itself may not be an ingredient in a plaintiff establishing their case, let's say for a defamation per se, or the inaccuracy itself goes a long measure in the success of a claim or injunctory relief. So, finally, I'd just like to come to the IT rules and just end it there. The IT rules, when they were made, they did not only provide the power of the to the government to label what was fake news, but alongside that power of labeling what is fake, false, and misleading, the government had that power with respect to any reporting with respect to the government itself, and there was the ability for the government then to issue a takedown order, a censorship order for any kind of fake news which would, in its own estimation, be fake, false, and misleading. This was struck down by the Bombay High Court, and it basically stated that the government here has been will exercise this power without any kind of safeguards which are in place, and it does not match the overall scheme of Article 19.2. I'll pause here, and we can get into further conversation based on responses which we have.
Thank you so much, Mr. Gupta. And I think we can open the floor for some questions and answers now.
Hello, thank you so much for a very interesting discussion. My question is to Vrinda. So you spoke about how in the current framework, the police can summon your phone, but they do not really have any right to go through it or hack it. So in that sense, I wanted to ask you, is it possible to have some kind of an ethical legal framework to hack phones to what extent can they access your data? Or should we have a more absolutist understanding of a complete restriction on it?
So I'm not sure how an ethical framework would work in terms of the law when you're talking about the police. I mean, our police are not really known for always following ethics. When it comes to hacking, I actually do think an absolutist framework is important. And even the law should not provide for exceptions like, oh, you can hack phones in the interest of law and order or to solve a crime. There are enough tools that the police already has to be able to access the contents of my phone. And as like with most things, and especially in criminal law, criminal procedure is very, very important because that is where your liberties come from. They don't come from substantive law. They come from the procedural liberties that like the CRPC guarantees. And I think having those minimal procedures as well, that you have to send a notice, you have to get that notice, there is a sort of proportionality in terms of what information you can ask for. I think it is important. Having an absolutist framework where you just say you can hack the phone if you think it is in national importance almost will make it impossible for you as a citizen to challenge that action. So I think in this case, an absolutist framework is necessary.
Hi, my question is for Mr. Kulkarni. So in your presentation, you mentioned that expanding the definition of the state to also include private actors could potentially lead to, say, backhanded restrictions on freedoms. But it seems that some of the most pervasive surveillance systems today are perpetrated by private entities and not the state. For instance, we have platforms like Zomato and Swiggy, which exercise extensive algorithmic control on the lives of gig workers. And they're essentially dictating every aspect of their life through opaque and often exploitative systems. So given that surveillance is no longer the exclusive domain of the state or the big brother, so to say, but is increasingly, something that is done by powerful private actors, wouldn't you say that increasing the scope of the state under Article 12 or through legislations beyond the state to also include these private actors would benefit the workers who often occupy an extremely unequal bargaining power in this relationship?
So the problem may be real. The object may be laudable, but the medicine is incorrect. The correct remedy, if you ask me, is if there is a problem, it must be regulated. What law says? Proportionally. Opening the floodgates of what is state will so disproportionately invade into what activity somebody is doing. And once those floodgates are open, they will have repercussions on other private actors. You see, when the law is modified, when the law is opened, it doesn't open only for one person. It will get into our homes someday. Therefore, the answer to every problem, there are problems. The answer to that problem is targeted and proportionate regulation, not an open-ended regulation, which can go in spiral in ways that we cannot imagine.
So just a small follow-up to that question. So instead of opening it up to everyone, we have judgments which talk about the functional understanding of state, where we're saying that any private entity which has the ability to wield powers that might potentially restrict fundamental rights of citizens should be considered a state. So in that case, shouldn't social media platforms which today do wield that power to violate our right to privacy be considered state in that limited capacity?
See, again, the problem there is the moment you ascribe functions of state to private entities, they will become accessories to the state in enforcing its writ. So it will affect things in ways that we cannot imagine today, which is why regulation always has to be focused on the problem that we are solving. Large scale alterations in for example, standing, which have existed in laws that we look up to, for example, laws that we have borrowed from for 250 years. State action doctrine has not expanded like we want it to, for good reason.
Right. State is completely dependent on these intermediaries to regulate free speech, because they are asking the intermediaries to, in a way, not only for regulating but also on surveillance also. So, I mean, state on its own cannot do as much surveillance as the intermediaries do through their various platforms. So therefore, my view is that it seems that both of them are working in tandem with each other. It's regulation of intermediaries by the state doesn't seem to be the real thing, because state is completely dependent on intermediaries.
Two things there. One is regulation of free speech. The other is surveillance. They're two different concepts. So far as the first is concerned, of course, state acts through some medium, but there the state passes recognizable orders that get enforced. And therefore, the there is a vast gap between what the two are capable of and what they do. So far as surveillance is concerned, to my knowledge, nobody is doing surveillance except for the state. So therefore, there is no question of conflating the two concepts.
Add to that in the sense of, practically speaking, it has not really been a challenge in bringing action against private parties, because you do it through the mechanism of the state. So, I mean, like all these social media companies do get sued by saying the state is not regulating it adequately enough. So when you challenge a blocking order, I mean, the blocking order is passed by the government and then carried out by any social media platform. So you make both parties. So it's, I mean, in practical terms, the court's jurisprudence has expanded that you say the state is not performing its actions of regulating. So it's not, you don't necessarily need to go against the state necessarily. And with respect to gig workers, actually, there is some litigation pending in the Supreme Court, not on work employee surveillance, but to say that, you're not performing enough protections for gig workers, and there's a social justice code which should be implemented. And the gig workers are saying, well, the platforms are saying there is a code, you have not enforced it as government. So first you want to enforce it. You cannot ask the court to enforce it when the government has a code but is not bringing it into effect. That is a legislative function. So that petition is sort of playing out. And I think to your question on surveillance and private actors, I mean, I think that you see in terms of it is, you're seeing this actually in the US a lot where, Palantir and all of these companies, the government is purchasing that technology. So I think there the interaction between private and state is, where are the data sets coming from? So the government doesn't necessarily always have the data sets. So if they purchase those data sets, whose data sets is it? Where is that? What is that being trained on? So if there is a facial recognition database, where is that coming from? And there is some sort of moratorium that has been passed either by cities in the US or through some orders of different courts, where they are saying when it comes to law enforcement, so you can't use facial recognition evidence in a criminal case because it may not, there's also problems of accuracy and bias and those sorts of things. So yeah, from that perspective, private action in surveillance is different from private action in terms of intermediary liability.
Hi, I had two questions, both for Ms. Vrinda and Mr. Park. So the first is related to the recent telecom cybersecurity rules that have been enacted. Specifically, the Rule 5 talks about suspension, temporary suspension and permanent suspension of certain devices when there's endangerment of telecom cybersecurity, which again is not defined anywhere in the rules or the parent act, the Telecommunication Act. So how do we interpret those rules in context of the Kunal Kamra case? And the second question is that you mentioned constitutional doctrine of the chilling effect. But currently the understanding that we have of the chilling effect doctrine is limited to certain fear of legal harms. But we also have scholars like Daniel Solve who talk about expanding it to fear of privacy harms and social conformity as chilling effect doctrine. So is there a way to incorporate these theories in the constitutional scheme as well?
Do you want to take the first question?
Hi, I'm just bringing up the cybersecurity rules. Yeah.
Yes, please.
You need to read the language. I don't give instant opinions. But yeah, I'm just looking at Rule 5.1. You were saying cybersecurity rules, Rule 5, right?
Yes.
Yeah. So just reading it out, the central government may put in place digital and other mechanisms as it may consider necessary to identify for enabling any person and other stakeholders to identify and report any act that endangers telecom cybersecurity, including through actions listed under sub-rule 3 of Rule 4. And sub-rule 3 of Rule 4 is without prejudice to so and so, no person shall use for fraud, cheating, etc. Bunch of things itself. And Rule 5.2 says the central government shall, after prima facie examination of the information received, identify telecom identifier, the use of which is alleged to have endangered telecom cybersecurity, the person to whom such telecom identifier has been issued, and issue such notice to such person. Rule 5.3 is written response. Rule 5.4 is response after being heard, assessment, and then suspend. So actually, Rule 5.5 is the penalties. Temporarily suspend use of the relevant telecom identifier for purpose of providing telecommunication services. Terminate the use of the relevant telecom identifier for providing telecommunication services. Now, in terms of delegated legislation and where we have been going recently, firstly, if it's not an express rule-making power which is emerging from the statute, that is nothing unique. What we've seen is that even if you look at the Data Protection Act of 2023, which has been passed, there is a large reliance on rule-making power, because if you look at both the Telecom Act as well as the Data Protection Act of 2023, they rely on something, a drafting approach in which they prioritize, at least as per the policymakers, an approach of simplicity and principle-based legislation, which is then supplemented by rule-making power, and it has been reasoned that this makes the laws more comprehensible, smaller, shorter, easier to understand, and the benefits which result are also of flexibility that allows the union executive within the broad contours of the policy choices made by the legislation to make rules. However, if you match that against administrative law doctrine, quite often the principles by itself, the policy choices are not present within the legislative framework. And it's just how we are making laws now. So quite often you notice that there is no anchoring provision, substantive or expressly rule-making provision, which is there within the statute itself. So even for earlier laws, earlier acts such as the Information Technology Act, you can quite easily argue that the expansion of the IT rules from 2021 itself to domains of digital broadcast news or digital OTT streaming platforms, which are there, video streaming platforms, is not within the confines of an action of an intermediary as it has been defined under 7987 of Section 21 XW. So this is something which is not unique. I would like to emphasize. However, as Manu was saying earlier, these laws have the potential of staying on the books for a long period of time, and quite often even challenges to them quite often do not succeed, as there is a presumption of constitutionality and reference to the union executive decision making quite often. So that's my answer on this.
Yeah, on your second question on fear of privacy harms, I mean, you could put that into a chilling effect. So like I gave the example of going in for a protest. So if I feel nobody's stopping me, a drone is not stopping me from going and attending a protest, but there is that fear that there is a loss of privacy because I will be identifiable to the state, which may be used in some future action. I mean, we're seeing this in the US everywhere, right? Like where a campus protest is now being used against you. So that is a loss of privacy harm. So from that perspective, I think it is already read into the idea of chilling effect. And your second question was on fear of social conformity. I think if you have to read that in, it would be through the idea of dignity, that there is a dignity and I have the ability to be who I am and to express who I want in a way that truly defines me. And so, maybe that would be the way you would bring it in.
Right. Hi, my question is for Brinda ma'am. Hi. Yeah. So, but of course, I'd love to hear other perspectives in this as well. So you did talk about certain practical ways that one can sort of talk to their client as like a side note to the entire discussion. However, what I want to know your views on is how the legislature has categorized these surveillance sort of bills and acts. For instance, the Aadhaar bill was introduced as a money bill in the Lok Sabha and under Article 110, which effectively barred its review under the Rajya Sabha, which sort of acts as another democratic procedural scrutiny for such legislations. And now with the Aadhaar Act also, the pith and substance of it was surveillance. However, the Supreme Court, in interpreting it, stated that because it has incidental provisions which relate to financial matters, that is why it is a money bill and it need not be routed through Rajya Sabha, which sort of opened floodgates for the legislature to categorize these surveillance legislations as money bills and bar review. So is there a doctrinal incorrectness that the Supreme Court in itself is sort of propagating over here? Are there ways to correct it? I just wanted to know your views on that.
Yeah, I mean, I think the court's decision on money bill was wrong. There's been a lot of great writing around kind of what were the problems with the court's judgment, because obviously it does give the government another way to avoid scrutiny or to lessen scrutiny when they want to push something through. And everything will have some impact on financial, on financial implications or of the state. So I think that decision was a problem. There has been a review, though I've forgotten in which judgment, but the court did say that these decisions, like so even the specific Aadhaar money bill issue, will be reconsidered by a 7-judge bench. That's obviously been pending for forever years. I think all of this is important because the government is basically finding more and more ways to introduce laws, whether it's through delegated legislation. So the point Apar mentioned, what we're seeing with the IT Act, right? There's been an explosion in legislation through regulation. So regulation that is meant for intermediaries, like in Section 79, is now regulating online content providers, right? Is regulating digital news providers. That is not what 79 from the text really absolutely at all means. And the second is this money bill route. And I mean, the only solution, so to speak, is really we challenge it in court and we hope there's a decision. So we have made the ultra vires challenge in the IT rules 2021, but because the matter has been pending for so long, it sort of has just allowed the government to introduce more and more bills, more and more laws through this framework. Because what happens when you try and introduce it through a regulatory framework? So, Manu spoke about Digital India. So there was this whole idea of Digital India, broadcasting bill. And because there was so much backlash, we've never really seen the light of day in those laws. That is because actually following a parliamentary consultation process is tough. Like you have to go to standing committee. If there is public feedback, you have to take that feedback into account. I mean, for whatever it's worth, even the Digital Protection Act took 5 years because there were various back and forth. And, it may not be as good as it was. And there have been problems with the public consultation process, but at least it followed some sort of consultation process. So I think the only real solution is, you hope that courts decide. And if they don't, then you kind of have to try and debate it in the public opinion and make sure that there is such a public response. Like that's what happened with the broadcasting bill. There was a genuine uproar over some of the provisions and there was a lot of pushback and the government said, okay, we're going to withdraw this and we'll come out with a different framework. And not to have a system where you have this Allahabad controversy, which everybody's like, oh my God, we have to regulate this. This is a real problem of our times. And then you go to court and the court says, we're going to expand the scope and let's come up with a law. Like that is not the way to do it in response to a public demand, because that is always going to be reactionary. And then that's the point, you need a law that's narrowly tailored. So those are, I think, the ways.
Yeah, hi. So my question is to, I think, everyone on the panel. This question of like algorithms that Suprath had brought up, I think is especially relevant because we have bigger and bigger entities like Google and Amazon harvesting behavioral data, of like millions and millions of people, which is then used to kind of influence their behavior in multiple ways, right? It's used to influence consumer behavior. And then we also had like Cambridge Analytica, which we have conversations about that, but then, I think the algorithm as something that, requires regulation, especially in the US, for example, they're using AI algorithms to kind of determine what your insurance premium would be, right? So in that kind of situation, where exactly, how does that factor into the question of surveillance? And, I don't think the DPDP Act, I'm not sure if it kind of covers this kind of like deep use of algorithm for, commercial purposes or,
other purposes. So how would that kind of question be taken up by the courts, or like how would we, what would be the possible regulation for that kind of thing?
So, three fundamental principles, as I see, will apply to a question like this are: one, is the user told? Two, has the user consented? Three, even if the answer to one and two is yes, three, is it lawful? If we look at it in this canvas, reasonably, in my assessment, one will be able to solve these issues. And what is essential is to correctly define what is lawful. If that is not done, we will not have internet. We will not have the kind of facilities that we have on the internet. One has to create a regulatory framework that is certain and clear and protects rights, and then allow people to operate in that regulatory framework. Otherwise, you will be shooting the messenger.
Hello. I have a question to Ms. Vinay.
Sorry. Sir, please go ahead.
When quite often we think about regulation of algorithms, we need to firstly think about what is the use of that algorithm itself. If it is for discriminative sorting of social media by itself, then we need to come at what is the social harm which is being caused due to that discriminative sorting, if there is any evidence which exists for it. And I think this gains a greater amount of value when we look at how rights and entitlements and benefits and subsidies are determined for the larger section of our country, the majority of people who are now being put through a technical system to get their food, get their cooking oil, and get their bar of soap. And here I think what is needed are some basic ground rules: the transparency, which is a proactive disclosure of how the state is using it, certification, internal studies. And if you look at the Biden AI order, which has now been rescinded, it essentially was a direction to the federal agencies in the United States to firstly disclose if they're using artificial intelligence. So there is a level of public understanding what is the basis of the decision by which they are impacted. Secondly, was to certify and to run tests and then to make those reports public. What this all enables us to do as a society is that the most significant impacts which come to us quite often does come from the state, as much as it may also come from corporations. However, what is much more important for us to first have is a form of evidence which comes through evidence seeking policies, through proactive disclosures, by us knowing what is the basis of decisions which are being taken on us when we are building all of this digital public infrastructure. Okay. The second point, which is coming up quite regularly in conversation here, has been a high amount of criticism, or at least I would say some amount of some amount of suspicion about big technology companies. It's been referred to in two or three questions which have come up here, which is why I think it's important for us to understand the political economy of this country, which is a very weak rule of law system. So if you remember, when the Wall Street Journal broke the story on Facebook not implementing its content moderation policies in India, the internal email of the public policy head of Facebook stated that they would face pressure in India on on the ability to financially for the ability to provide their services, which is service availability. It will impact them financially. And second was staff security. It indicates that we do not live in a high rule of law society, right? So the rules, when they do come into existence, quite enable certain amounts of action which also amount to administrative bullying. For instance, if there is a rule, it is discretionary on the government to enforce, it is vague, then or it has come through unclear legal grounding, such as administrative notification, it will enforce it only to the extent and only on them with whom there is a sense of unhappiness, or it can't reach a kind of a deal in a way, right? So we need to understand these realities, because quite often we are being influenced by the European framework, and I quite like the European framework, how they fit legislations within what they call as common European values. They made legislations. There's a lot to learn from that. But their understanding comes from their trust in the ability of the state and the erosion of the authority of the state due to large technology companies. What you may want in a South Asian country with a very weak rule of law system, where governance and politics are intermixed at a ministerial level, is to have a level of friction between a big technology company, which is a smaller giant, with a bigger giant, or with a bigger leviathan, which is the state by itself. And here again, I would say there is a need to first look at the state itself, how it is regulating itself, because it has the highest amount of power to deprive you of what is entitled to you, as well as punish and discipline you in ways which are unimaginable, right? So I think big tech is a problem, but we need to enumerate those problems, have the evidence, and regulate it in a way which does not result in greater power, which is concentrated with one specific ministry with unclear legal grounding, and then is applied in a discretionary manner and without transparency, which is what we see with social media censorship today. So the big problem here is not that Facebook or Meta or these large corporations are censoring you. Quite often, they are not being permitted to also disclose to you that they are censoring you under government orders and directions.
Hi, so I have a question. And because this is to Rinda, and you spoke about how, we sort of need the judiciary to intervene and how the judiciary's role is specifically important. In the recent Ranveer Alhavadia's case, when there was an approach to say there was a case of jurisdiction that Ranveer approached the court for, the court rather imposed a conditional sort of ban where it said only if you maintain the desired standards of decency and morality can you then post further content on it. Well, it's also important to remember at this juncture that the content that was posted was made on this YouTube channel, India's Got Latin, which is marked and marketed as an 18+ purposes only. So these are people that have paid for such content. So can this be read? Can the judiciary's order sort of be read as prior restraint? And a question that follows from that is, even though India's history and its jurisprudence on free speech is different and not absolutist like countries like US, can we see prior restraint is even constitutionally valid then?
Yeah, I mean, I think this is a big problem. And I think imposing it as bail conditions is an issue because, and this is not the first time, and the Supreme Court has done it, but there are instances in across high courts where as a condition of bail, you do say don't access social media, switch on Arogya Setu. Like during COVID, a lot of the orders were like your Arogya Setu has to be on at all times. So you're being tracked at all times. So there is a history of courts imposing these conditions via bail orders. And there's two problems with that. One, realistically, nobody's going to challenge the bail condition. At that point, you're more concerned with personal liberty and you're like, whatever I need to do to stay out of jail, I'm going to accept that. So on a practical matter, that becomes very difficult to challenge. And when that becomes very difficult to challenge, it becomes very easy to set a precedent across courts that, oh, Supreme Court has done it, so now, of course, I can. The second is also there is no counter discussion on this, right? There is nobody saying, look, I mean, the arguments you're making, nobody's really saying that actually this was this is a YouTube channel. It was meant to be for above 18s only. So why are you imposing this restriction? As long as I'm compliant with law, there should not be this kind of prior restraint. So yes, I mean, I think this is a problem. I also think our constitution does recognize that prior restraint is problematic. So I don't think, one can easily make an argument that this is not permissible. Although some of the judgments like the High Court, Karnataka High Court judgment, which permits blocking of accounts, to some extent that is prior restraint. So that is saying, yes, because of your pattern of history in the past, you are now just prohibited from ever accessing this social media platform. Because also because of Twitter's own policies, it's not like I can have one account deactivated and start another account. Like you're not actually permitted to do that. So in effect, you are stopping a person from posting on that platform completely. Yeah.
Ms. Rinda, I
Let
have-
me just add there. I have a slightly different perspective. Let's take this very case. What is the law today? The law says current community standards. Now, current community standards, we cannot look at what all of us in this room think. Current community standards will also be what a farmer, if you know one, thinks. And if you look at the content from that perspective, it's problematic. If you don't admit it's problematic, if you don't admit that the law as it stands today, unless you say the law must be changed, which is valid, one can say it, but unless we look at it like that, we will never understand what truly goes on in court. Because ultimately, law is not what many of us think sitting in an air-conditioned room. Law is how it is practiced. American realists have said that 100 years ago. A person on the street will find that objectionable. The law must respond to that. Now, how the law responds may be in more ways than one. The law need not necessarily, for example, initiate criminal prosecution. But if the law does not respond to what people think, then people will take the law into their own hands.
Ms. Rinda, I have two questions for you. In the US, courts have started assigning heightened protections to search and seizure of digital devices, such as necessitating warrants, like in the Riley versus California case, right? Now, do you think that is something that can work in India, given that oftentimes violations or breach in the data privacy of individuals are justified under the guise of safeguarding national security? And secondly, how do you think the ratio of the Katikalu Oghad case stands with respect to the how search and seizure of digital devices is carried out in India? Because it talks about self-incrimination. And I don't think in our country, when discussing the case, this aspect is really touched upon by the courts or by legal practitioners.
I'm actually going to put Abhinav on the line because he has written extensively on this. So everything that I've written on this has actually relied on what he said. So maybe if you don't mind. But yeah, very briefly, I mean, I think the petition that we filed in court is to say, look, again, this comes to a problem of, in a practical perspective, nobody's going to be able to challenge this. Like if I'm asked to give my phone, it is very unlikely that I'm going to challenge that in court. So the idea was that you move it as a sort of PIL to say, look, we need guidelines because Katikalu Oghad does not apply, should not apply in the same way when it comes to this kind of evidence, because this is compulsion and this is compelled testimony. Because when you have my phone, you just have a vast trove of information about me that you will not just necessarily have from my DNA. Because also what happens with a phone is that it gives you the ability to link up information and different data points, right? So you, in some senses, have a much more comprehensive profile about you as a person. And that's why I think, so one of the prayers is frame guidelines, right? Like don't leave it, if you don't want to leave it just to the courts, either direct the government to frame some guidelines, because currently there are no guidelines. The government comes and says, oh, there's a CBI manual and that's enough, but really that almost is not enough. So I think that's why the idea of going to court was to say, either direct the government to act. In general, I'm not in big favor of the court first issuing guidelines, because that can often be difficult. And also when the court frames guidelines, then you almost can never challenge it. Whereas if you give back the power, there is still that conversation between executive, government, and judiciary. So that is what we are trying to say. That today, the context in which Katikalu was argued, or even Ritesh Sinha and voice samples, is very different from this kind of testimony that you get from the courts.
Hi, this question is to both. This question is to both Vrinda and Manu. So it's probably follows from the last question, but in context of the new Finance Bill 2025, where essentially it provides an ability to decrypt chats from WhatsApp and Telegram, and also see your Google Map history, etc., for financial tracking. So now the question comes down to whether are we legitimizing state access to private information, where essentially like is financial surveillance becoming a way for state intrusion now? And a small, another question to that would also be, how are increasingly legal frameworks coming to back these? For example, now it's come down to financial surveillance. Of course, there's always the national security versus personal liberty debacle in this context as well. So this is the context in which I'd like you to share your perspective.
Okay, so again, the elephant in the room, there are two. Is there money laundering? Is there drug money? The answer is overwhelmingly yes. So if we start looking at it by saying, look, this is intrusive surveillance, we have missed the picture, because nobody is going to look at like that in real life except in this room. The question then is, how do we define those limits? So this question came up in Mapp versus Ohio for the first time when the US Supreme Court said an illegal search and seizure is wrong. These arguments were considered at length. Ultimately, the court said, if you don't follow the norm, you will restrict freedom even more greatly than securing a conviction. Therefore, what is needed is not whether we need a norm. Most certainly we need a norm, and one cannot say there should be no surveillance. That will not function in real life. But it must be very narrow, and that narrowness must be strictly enforced, even at the cost of letting a criminal go free.
Yeah, just two things on that. So actually, I've written a paper, you can see it, on FATF and KYC and the surveillance. So how the KYC framework, which emerges from the FATF, and what are the privacy implications? And just on the point of narrow tailoring, actually one of the best parts of the Aadhaar judgment, which a lot of people don't realize, is when they strike down the bank linking. There's a great quote that they talk about: the ritualistic incantation of black money or money laundering is not enough to justify the compulsory linking of your bank with Aadhaar. So it should not just be, like the presumption of criminality, that, everybody is going to be doing something illegal. Also, there should not be this ritualistic incantation. It should be narrowly tailored. There should be some basis to say that I have, a history which would justify financial surveillance.
Sorry, I had a question for everyone on the. Am I audible? Yeah, now it works. Sorry. So it flew from Manu sir's last comment about, enforcing a strict regime, and from a practitioner's perspective, what we are seeing is that a lot of the IT Act regulation and the enforcement of it, largely the remedial model is to go to the High Court, because there's a real absence of, whatever might be the other means to really seek any enforcement. And when you go to the High Court, then there are obvious delays at practically all High Courts. If you don't get an interim order or a rule issued in the notice stage, then you're stuck. So what thoughts would be there to sort of develop alternate remedial models, which might be more realistic to secure some sort of speedy enforcement for these things? Because right now, I think the writ model is sort of falling apart.
So the one practical difficulty is the person who's enforcing the order is by law prevented from disclosing. So that itself takes, and it's there in Rule 16. So it's written in law that law is not set aside. So if you ask me, we need better defined law. This ragtag legislation of going on adding rules one after the other is simply leading to chaos. Every time you challenge a rule, the rule gets amended, you amend the petition. It's a never-ending process. So therefore, to say there should be no regulation doesn't make sense. It's when regulation is clearly defined and is certain that all of us will be able to take it to court.
I just want to clarify. My point is flowing from that only, that if we go to court, courts are effectively a black hole right now. Because in terms of actually getting an answer, let's say if there is a challenge, even if maybe the best defined law in terms of the text of the law, the problem that is sort of arising is with a lot of the challenges. And sir, I mean, I know that you are also there in some of these, where effectively when we go to court, we are sort of stonewalled because that hearing takes so long that the damage is either done or precipitated such that the hearing is effectively left to only serve an academic purpose. So what might be an alternative, or is there any possibility of coming up with alternate remedial models? Because the harm is so quick. So maybe courts are really not where this is going to work out in the long run, given our courts.
You see, tribunalization, I think, is a failure. And law really, development of law gets curbed in tribunals. At least in the High Court, law evolves. It may take long. So I can't, tribunals really, are, to ask me personally, it's a non-starter. For example, this GAC is worse than the cases. So, yeah. So there is something called the Grievance Appellate Committee. The committee is set up comprising only of officers of the state. It does not have any members trained in the law. Now, ad hoc adjudicatory bodies like this, especially, this is not judicial adjudication, this is administrative adjudication. They pass orders left, right, and center for takedown of content. So, means a civil suit in a court would have been a slow remedy, but a far superior remedy in terms of eventually defining the law. These ad hoc mechanisms are truly not the answer.
I think with that, we'll close. I'll just check with all the panelists if anybody has any final comments to offer. Okay. Thanks very much, everybody, once again for making the time. Thank you for making the time to all the panelists also. And I'm sure all of us have learned a great deal from 1.5 hours ago. Thank you so much. And yeah, please have fun.
Which one?
Yes.
Hey, before we wrap up, just that I'll request everyone, every student to just stay here for a moment while panelists and other faculty members leave outside. And after that, we can leave in organized fashion. Okay, so just to announce that first and second year leave from the podium side, and the third, fourth, fifth year and LLM lead from the other side of the room. And just stay here for a moment, like a minute. After that, please leave. Okay, thank you so much. The next panel will begin around 12:15.
Hi, can you all see and hear me?
Yes, sir, we can.
Okay. It's coming through clearly, right?
Yes. We'll start by 12:50. We ran a little bit late on the process.
No problem. No.
Good afternoon, everyone. Thank you all for all of you for joining us today. Uh, this panel is focused on fiscal federalism, and it's not only going to look at the MADA judgment and the judgment on alcohol, but also questions that have been raised by the southern states on GST and generally the nature of central devolution and how that affects state finances, especially in light of the change in taxation from VAT to GST. So we're going to start with Alok, who, as we all know, is the founder and heads Vidhi in Karnataka. Alok is just going to run us through questions of devolution and center-state relations when it comes to finances, especially in light of the recent conclave that was held by the Southern Ministers of Finance. So Alok is joining us online and we'll start with him. Alok, can someone check with Alok?
Hi everyone. Can you see and hear me? Iman, I can't hear you.
Can you hear me now?
The sound is not coming from your end. You guys are muted for some reason.
Alok, can you log in and log out?
No, it's still muted. No, I think someone at this thing end has to change. I think the mics are working fine. Nope.
Can you hear me now?
Okay, just speak now.
Yeah. Hello.
Nope, not able to hear you.
Hello. 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 Check.
Can't hear you.
Check.
Just let me log out. It might be a problem at mine. Let me log out and log in.
Didn't you guys do a mic check?
Hello. Alok, can you hear us?
Just log back in.
Yeah, he has logged out.
Hi, can someone say something?
Something. Hello.
Yes, perfect. I can hear you.
Thank you.
Thanks.
Yeah, Alok, you're up. Please guide us through what's been happening generally with respect to devolution from the center, finances, both the centrally sponsored schemes and the debates over, southern states and their angst against the union's fiscal policies. Yeah.
Thanks, thanks, Simon. I think those of you who have read the concept note will get a very broad idea. But I think I realized that this was a topic that we as constitutional lawyers never really covered. When we studied constitutional law, and I don't know if the syllabus has been updated of late, Finance Commission, we knew of its existence. We didn't know exactly what it does. We knew it was a constitutional body. We understood very basically how money came to states from center, but I don't think we went into it in any real depth. And I suppose our understanding of constitutional law was kind of limited to what the court said about the constitution. So I think the challenge now, and I'm very happy that this topic has been covered in the last few courts and constitutions, has been understanding how the constitution understands flows of money from the union to the states, why that's important, and the bearing that it has on our federalism at large. So let's understand some basic concepts first. For any state government, right, there are broadly three sources of funds. There is the money that it raises on its own through its taxes, through its fees, and I'm including in this the money that the Finance Commission allots to it from the center's share of taxes, right? A certain percentage. This is the state's own funding, if you want to call it that way, because in some senses, this is not somebody doing charity by giving it to them. The second source of funding is what the central government gives it. And again, there are multiple sources. There are grants the central government can make. There are one-off grants. There are schemes for which the state has to be a party and the money goes to the states for spending. So I'll put it this as the discretionary grants. It's a very broader term than what strictly the constitution says. And the third source of funding for the state is debt. Debt is something which, you know, we take for granted, but we never think about it conceptually. Someone like the late Dave Graeber, who's written a fantastic book on debt, a history of 5,000 years, sort of reframes debt as borrowing energy from the future. We are sort of saying, I'll pay this back to you in the future when I do the work, when I do something. In the context of a government, it's essentially a future tax, right? You are saying that I am borrowing this from the tax that I will collect in the future. You are hoping that the tax increases on its own, but you would probably have to levy new taxes. You may have to collect more from more people. So in a sense, it's a little bit like saying, I will collect a future tax from the future and use it now, right? And that's, if that sounds somewhat science fiction-y, it's only because we haven't really updated our concepts in this. We just take for granted these ideas. Now, coming specifically to state debt, which I think has seen a very interesting development in the last year. And I want to give a context for this in a little bit more detail. You have Article 292, which allows the union government to, borrow money on the Consolidated Fund of India. There is only a limitation that it may at best be limited by law made by Parliament. Parliament did not make any law restricting how much debt the union could take for 50 odd years. It was only in the 2000s that we have the fiscal responsibility and budget management legislation, which came as a result of the E.A.S. Sharma committee, which said that it's high time that there is some mechanism which has to be evolved to control how much debt union governments take. Because the understanding, of course, like I said, right, no debt is free. At the end of the day, it has to be repaid. And where does it have to be repaid from? It is repaid from taxes. And when taxes have to be collected from the future, you are essentially taxing the people of the future who have no say in what kind of debt you take today. So in some senses, this was a forward-thinking legislation which said, let's put some checks, let's put some limits. Let's limit what percentage of our, how much debt the government can take. We have a debt ceiling limit today of about 60% of our GDP. And specifically for the government, each year, it cannot borrow more than 3% of the GDP as fiscal deficit, right? The fiscal deficit is the spending minus the actual revenues that you have raised from various sources. So this gap cannot be more than 3% of GDP, not 3% of budget. Just keep these ideas in mind because it will become relevant very soon. Now, this was a central government legislation, but it also applied to state governments. Now, state government debt is governed by Article 293. Now, if you look at Article 292 and 293, they're of course dramatically different. Because while 292 says, yeah, center can raise whatever debt you want, just make it according to law made by Parliament. The concept for states is slightly different. The state government is allowed to raise debt on the basis of the consolidated fund of the state, but subject to such terms and conditions as the union government and Parliament may by law apply. In fact, 293 has 4 clauses, and one of the most important ones, and I'll read it out for everyone's benefit because this is not something which we usually encounter on a day-to-day basis. A state, clause 3, a state may not, without the consent of the government of India, raise any loan if there is still outstanding any part of a loan which has been made to the state by the government of India or by its predecessor government, or in respect of which a guarantee has been given by the Government of India or by its predecessor government, right? And clause 4 says a consent may be granted subject to such conditions as the Government of India may think fit to pose. Pause here for a moment. This is not very different from the pre-constitutional position under the Government of India Act. There was no real debate about this because everyone is like, yeah, fair enough. You know, the states, if as long as the union is going to be lending money to the states, they're perfectly fine if the states have to take the union's consent for raising loans. But something changed in the 2000s. And what changed in the 2000s is actually two different sets of phenomena. And for more details on this, I would urge you to read a report that we at the Vidhi Center for Legal Policy, my colleagues Orgo, Ritvika, and Anisha Sharma, who now teaches at Ashoka University, she's an economist, had prepared on state debt. And we had submitted this report to the Finance Commission of the then 14th Finance Commission. 14th Finance Commission had actually reached out to us. So this is a commissioned piece of research, but it is public and it is available on the Vidhi website and the Finance Commission website. Something changed in 2000 which made this situation somewhat not untenable, but ripe for change, let me put it that way. So for example, in 1991, 50% of all the loans that states took, they took from the union government, right? So there was no problem in operationalizing 293(3), where union would say, boss, you've borrowed enough, just tap it down, reduce it less, because anyway, I am your biggest lender, so please keep a check on this, right? Which is fair. Now, two changes happened in the 2000s, like I will say. Number one, states, and this was a result of Finance Commission recommendations, states now borrowed from the National Small Savings Fund. This is a public account which was set up. This is not from the union. It wasn't the union lending to it. The National Small Savings Fund is something which collects all money from small savings and lends it to the states. So a lot of states borrow from there, not from the union. The second thing that happened was that the Finance Commission also recommended, the 12th Finance Commission, recommended that, instead of the union borrowing and giving to the states, let the states borrow from the market. The logic was sound because they said that states which are fiscally profligate will have to face higher interest rates. States which manage their budget much better will face lower interest rate. So by the union, it's not like the union is a bank which can set differential interest rates for different states. It would essentially, of course, borrow at this one rate and have to lend to the states at another rate. So which meant that there was no incentive for states to be better run or for, keeping their finances in check. So what the Finance Commission recommended, and the union accepted this, they said, we will not borrow and give to the states. We will stop that mechanism, but we'll allow states to borrow from the market and let them be subject a little bit to the discipline of the market. So this meant that by 2013-14, which was when our report was prepared, the union's share in states borrowing had shrunk to 6%. Okay, and some states were well on their way to having no money being owed to the union. Now, when the Finance Commission made this recommendation in the 12th Finance Commission made it in early 2000s, I don't think they exactly imagined that no state would have any borrowing from the union, and I don't think they imagined the implication for Article 293, Clause 3, which, as you'll recall, and as I've just said, the union has to, sorry, the state rather, has to take the consent of the union for borrowing further loans if it owes any money to the union, right? Now we're getting to a situation where states will not actually be owing the union any money. So how will the union regulate the taking of state debt? And this is not a trivial problem, because if state debt is essentially unregulated, you are talking about wider macroeconomic implications. Because let's keep in mind that India, unlike the United States, for instance, where there is a constant tussle between the executive and the legislature over how much money to spend, here the executive and the legislature are more or less the same, right? If you have a majority in parliament, there is no real check on how much money you can spend, except the need to maintain macroeconomic stability. So there was a fear that states will just feel no need to be restrained about their debt. And this is also a somewhat structural problem in liberal democracies across the world, not just in India, because debts don't become due in 5 years or 4 years or 3 years or 2 years or 1 year. You have to spend. There is a demand from the public that spend more money on me. So I will take debt. I can't obviously raise taxes beyond a certain limit. So you finance a balance with debt. And if, of course, you think that if it works, it'll be your problem. If it doesn't work, it's somebody else's problem. So there is a set of inbuilt perverse incentives which might increase the size of the debt, and this is a problem worldwide. This was a problem which, in a certain constitutional context, where we have 293 as it stands today, the union had a certain power to control and regulate how much debt a state government would take. But as I mentioned, with the share of union debt from states increasing dramatically year on year, there is less and less control. Which brings us to a more specific context of 2024. Well, before I go to that, that problem has slightly been pushed further back because of, thanks to, of all things, COVID. In 2022, I think when I last checked figures while writing my EPW article, I think the number had gone up to about 8%. But again, that just means that it's not as if dramatically states are borrowing more from the union. It's just that the date at which states will not owe any money to the union will go to a later point of time. Okay, which brings us to a specific issue which I think I've been asked to talk about, which is the Kerala government's suit against the Union of India. This is an entirely unprecedented suit because 203, I don't think that there has been any judgment interpreting 293. There is no way in which the court has a very clear, exact answer on the challenge that is being faced. But what was the challenge? Kerala wanted to raise about 26,000 crores as a loan, and the union government said, no, you cannot do so. Kerala government said, why not? I am not taking this on my account of my, sorry, I haven't reached my 3% limit of fiscal deficit. How can you tell me not to take this additional loan? The union government said, you Kerala government have been using your PSUs to borrow money, and those PSUs have been giving you that borrowed money, which you anyway have to return because your PSUs are not these great industrial behemoths which will eventually pay back that money on their own. You are effectively standing guarantee for that. So therefore, these are your loans as a Kerala state government. Again, I'm simplifying because this is not a economics conference, it is more of a constitutional conference. So I'm simplifying to this extent. So Kerala went to the Union Supreme Court saying, direct the union to allow us to borrow about rupees 26,000 crores because we have not violated the FRBM legislation. The union, of course, says that no, you can't be allowed to do so. 293 allows us to impose this limit. And in any case, you have breached this limit. Now, there is an arguable case for Kerala and there is a difficult case for Kerala. The arguable case for Kerala is that you cannot count PSU's debt as the state's debt, even though I may have stood guarantee for it. Because at the end of the day, PSUs are still a different entity from the state government. There is a different bankruptcy and insolvency regime for them, which obviously you can't file insolvency and bankruptcy proceedings against the state government itself. So the debt which is owed by PSUs, even if I'm giving a guarantee, even if they are owned by me, should not be counted as my debt, is what the Kerala government has a somewhat arguable case. The difficult case for Kerala to argue is the constitutional validity of the amendments to the FRBM legislation in 2018, which imposed these limits in the first place. The FRBM legislation basically says you cannot have, you cannot exceed a fiscal deficit of more than 3% of the GSDP, and when counting this 3% of the GSDP,
Hello.
Yeah.
Sorry to interrupt. We lost you for a bit, so could you just continue from?
What was the last thing that you heard?
Yeah, the FRBM legislation and the challenge.
Yeah, so Kerala has challenged the constitutional validity of the FRBM legislation, which is a little bit of a tough challenge because they are saying it violates Article 293, which I don't think so, because 293 allows the union parliament to frame legislation on the basis of which the union can give or not give its consent on these loan matters. Anyway, be that as it may, this is just my prima facie preliminary understanding of the positions that the respective parties have taken in this particular litigation. We don't know exactly how long the Supreme Court will take. The matter has been referred to a 5-judge bench, and because this is something which I think the court is right about understanding that this is not just a Kerala problem. This is a problem which other states might face going forward. It is not just a problem when there is, let's say, animosity between the union government and the state government, that this may be an issue that most state governments will start questioning whether the union government has any power to regulate state debt. And this is where it comes back to the earlier point that I made, which was in our submission to the Finance Commission, the 14th Finance Commission, which is that there is a need to relook at our constitutional framework for regulating state debt. There are 2 or 3 options that we have given, and I won't go into that specifically. I can discuss it later. I think, how much time do I have, Eamon?
You have about a minute.
Okay, sure. And I won't take too much time there. There are 2 or 3 options, and it involves, some of which involves constitutional amendments, some of which involves other mechanisms. But the fact is, you cannot have a federal democracy where states will eventually can go on a spree collecting all sorts of debt and leaving it to future governments to solve the problem. There needs to be union regulation of state debt, but we need a new framework which kind of takes into account this reality which has emerged in the last couple of decades. And finally, I want to leave you all with the thought that perhaps it is a good thing that we are having this conversation before it really becomes a crisis, where we can kind of debate the solution and debate what is the way forward in a manner that fits within the larger conversation on federalism. And of course, I'll not go specifically into the Finance Commission and others, which I think Sudhit and Pankhuri will cover, and we can leave some of it to the question and answer. So thanks, Eamon. Thanks, everyone. Sorry, I would have loved to be there. Some emergent circumstances meant I had to come back to that.
Thank you, Alok, for giving us the context of how the union and the states deal with their fiscal relations. Especially important is the whole business of 293, which we as lawyers don't pay attention to. But just as an aside, during the COVID period, when the union failed to make its GST compensation, there was a scheme created by the union government under 293, where states were allowed to borrow additionally, provided that they carried out certain reforms within the state. So that was almost identical to like a World Bank structural adjustment program rather than any constitutional scheme. So moving on, we have Pankhuri, who's an assistant professor at BML Munjal University, and her scholarship deals with GST and federalism generally, and we'd love to hear more about the issues concerning GST and the fiscal relationship between the union and the states.
Yeah. Good afternoon, everyone. So I would like to start by expressing firstly my heartfelt gratitude to Professor Kakrala and his team for inviting me, and to the volunteers who often shoulder tedious and unnoticed responsibilities in organizing events like this. So today I'll discuss fiscal federalism, a topic I have been working on. The issues surrounding it, especially the concerns expressed by the states, have not subsided. And in fact, they seem to persist year after year. One of the most prominent issues that continues to linger is the debate around autonomy and financial fairness between the center and states. My journey with fiscal federalism began with the implementation of the much discussed harbinger of pooled sovereignty, which is known as Goods and Services Tax Law in India. After years of deliberation and disputes, GST law was finally passed by the Indian Parliament in 2017. Now, it's crucial to note that Indian states weren't unaware of the implications of GST, especially regarding autonomy. In fact, the GST process took over 17 years of back and forth between departments and offices. Moreover, when the 101st Amendment Bill was passed, the ruling party already held powers in around majority of the states in India. So anyone wondering why the states agreed to the GST despite the autonomy it might strip away from them might understand this political context also. Alongside the center's push for GST, there was also a mantra of one nation, one tax, which painted a picture of ease of doing business and hopes of simplifying India's complex indirect taxation system. Of course, the intention behind GST was to end the cascading effects of taxes, that is tax on tax, that burdened businesses. While I'm not here to oppose the rosy picture painted for the Indian economy, there is one simple, direct question I ask about this. Good and simple tax, at what cost? The cost here in the question is the cost of autonomy for states. This therefore also leads us to the concerns raised by state finance ministers, particularly at the recent South Indian Finance Ministers Conclave held last year. States like Kerala argued that the 16th Finance Commission, the terms of reference for it should better reflect regional disparities, especially since the outdated 1971 census data often penalized rapidly developing states. Another significant issue which was raised by them was the ability of states to borrow, particularly under Article 293 of the Constitution. The center's control over borrowing severely limits states' fiscal autonomy, as discussed by Mr. Prasanna. Alongside this, the need for increased untied funds and fair devolution of resources became central point in those deliberations. To break down these concerns, I'll first address the distinction here, which is also made by economist Pinaki Chakravarti. He highlighted that discussions around fiscal federalism often conflate the distinct issues of fiscal stability, need for more resources of states, and fairness of transfers. These three are distinct issues which are generally conflated in the discussions on fiscal federalism. These might seem like interconnected issues, but they require careful dissection. Now, to give a fair picture and not to make it biased in its outlook, let's start by recognizing the fact that fiscal transfers to the states aren't confined merely to budgetary flows. There are non-budgetary resources like centers spending within the states, investment from PSUs, and even foreign direct investments that play an important role. Unfortunately, many discussions focus only on budgetary transfers, overlooking the broader non-budgetary flows, which often favor wealthier states, exacerbating fiscal inequalities around the country. Now, coming to the point of our discussion, which is on budgetary flows. Central tax sharing, as per the recommendation of the Finance Commission, serves as a primary means of these transfers, especially after the abolition of the erstwhile Planning Commission. The goal here is twofold: fiscal stability within each state and fiscal equalization across the country. Fiscal equalization, it means states should be able to at least equalize the public service delivery. Under the Indian Constitution, the center, we all recognize the fact, there is no denying of that the center has disproportionate taxing powers, which creates an imbalance. The center collects a substantial portion of the revenue and is responsible for approximately 37% of the expenditure, which, like in contrast, state handles around 63% of total expenditure. So obviously there is a function resource imbalance. In this context, taxation autonomy is central to fiscal federalism. It refers to the ability of state governments to set, collect, and manage taxes with minimal interferences from the center. The introduction of the GST law has obviously disrupted the landscape of indirect taxation, diminishing states' autonomy. One of the pressing issues regarding the GST system that demands attention, apart from the others which are regularly discussed, is the treatment of integrated GST, integrated goods and services tax, that is IGST component of the GST revenue. We all know GST revenue is divided in three parts: central GST, state GST, and integrated GST or UTGST. According to Section 17(1) of the IGST Act, the center appropriates the CGST portion for itself, and under Section 17(2), the SGST portion of the states must be appropriated to the states. However, what is happening in reality? The SGST portion is SGST portion is supposed to be out of the Consolidated Fund of India, but in practice, the entire IGST collection is reflected in the Consolidated Fund. It raises questions about the proper allocation of IGST revenue. Moreover, the treatment of IGST revenue has been misleading. We have been hearing in media and on Facebook and other, like on the social media also, Twitter, we have been hearing from the government about how GST revenue is increasing over the period of time. So therefore, it's actually a good and simple tax. But please note that the GST revenue data also include major portion of IGST revenue. And since the full IGST revenue is reflected in the Consolidated Fund without accounting for refunds, sale returns, export duties, and other exemptions, the data itself is misleading. As we all know that exports are zero rated. It means that there would be refunds, but those parts are not calculated while reflecting the same data in the Consolidated Fund, which leads to inflated data. So it distorts the actual tax revenue figures, provides inflated GST revenue figures, and misrepresents the true financial position of GST collection. Now let's turn to the Finance Commission's role. The role of Finance Commission is to address the function-resource mismatch. However, central interference with the Finance Commission's independent functioning has led to significant reduction in that part also. Just to give a brief idea, that 14th Finance Commission, although it increased the tax devolution from 32% to 42%, but MG Rao, one of the members of the Finance Commission, he actually showed through the calculation that the actual increase was actually very minimal. It was because Planning Commission was abolished around the same time. So therefore, that fund was also consolidated with the Finance Commission. And therefore, we cannot compare that 32% with right now the 42%, which was recommended by the 14th Finance Commission. With that, the share of non-shareable cesses and surcharges in the central GST revenue grew significantly. Just to give an example, from 10.4% in financial year 2011 to 12 to double 20.1% in 2020. So why is this important? Because the introduction of GST, which was aimed to be a harbinger of cooperative federalism and pooled sovereignty in India, has ironically been also accompanied by an increase in the center's reliance on cesses and surcharges, reducing the divisible pool for the states. Compounding this, the Finance Commission's grants to local bodies. We have covered IGST part, we have covered how the data are a bit tweaked, and now coming to the third part of this presentation. The Finance Commission's grants to local bodies, especially rural local bodies and urban local bodies, reveal another area of concern. Increasing conditionality attached to these grants. And I'll give you one example. 15th Finance Commission recommended 4.4 lakh crore in grants for local bodies from 2021 to 25 to 26 financial year, focusing on health infrastructure. So it was 4.4 lakh crore. However, a significant portion of these grants was tied to stringent conditions, like 54% were recommended for RLBs, that is the rural local bodies, 28% for ULB, and 16% for primary health sector. And they were supposed to be channelized through the local bodies. But the data shows that only about 80% of the total grants have been released yet. So these delays and uneven distribution of grants further hindered the ability of local bodies to address their own needs, and which they are mandated to fulfill under the Schedule 7 of the Indian Constitution. Please note, the issue here is that with the conditional grants, and that's what Mr. Prasanna was also trying to highlight the point, that with the conditional grants by the Finance Commission, the intergovernmental transfers, the idea behind the intergovernmental transfers through the Finance Commission is supposed to be a mandatory one. But if the conditions are attached to the same, then it takes the color of being discretionary in nature. And why is this important? Because the funds channeled through Finance Commission are claims of the state. And I'm quoting and unquoting claims. These are the rights of the state, and they should not be deceptively made discretionary grants channeled through the center due to the imposition of centrally mandated conditions. And it also sways Finance Commission from its mandated role of matching that function resource mismatch. Now, moving further, there is also a continuing debate regarding the use of population data from the 1971 census versus 2011 census. The argument here is very simple, that 1971 census fails to reflect the demographic changes that have occurred since then. Some states, particularly those that have successfully managed population growth, argue that they are unfairly penalized. Now, please be with me on this. And because this is really interesting here. The point to note here is that even though the Finance Commission shifted to 2011 data, census data, they also introduced another variable in which was demographic performance, about which southern states are same. So demographic performance was also included as a parameter, which is basically a proxy for population control. It was introduced for the same argument to balance the use of 2011 population metric and reward states that had been effectively curbing population growth since 1970. Still now it's very fair. But why southern states then are they are having a clamor over this issue again, if their efforts are also being accounted for? The reason here, the elephant in the room is this. The demographic performance, which the Finance Commission, 15 Finance Commission has also taken as a parameter now, and around 12.5% is allocated for it, is measured with the help of a statistic known as total fertility rate. Now, what is total fertility rate? It's the average number of children born to a fertile woman through her childbearing areas. However, as per the Commission's methodology, in order to determine the statewide share, what has Finance Commission done? The inverse of TFR has to be used. It means that it is multiplying the total fertility rate with this 1971 population to determine the share of each state under the demographic performance. It means those states which were having higher population in 1971, according to 1971 census data, if you multiply any factor with that, it will lead to more result when compared to the states which had lesser population during under the same data. Therefore, southern states and those states, they are complaining that the calculation of this criteria of demographic performance itself is kind of hampering them because you are using 1971 parameter for the same. Why this multiplication has to be done? Next, the issue, I'll just take 2 more minutes. Next, the issue of tax effort, which again the southern states are claiming here that we are making better collection, we are having more taxes and etc. The issue of tax effort parameter, it was introduced by 15th Finance Commission, but the problem here we have to see here is, so firstly, what is exactly tax effort? Tax effort is measuring the tax to GDP ratio. So GSDP actually, gross state domestic product. So tax to GSDP ratio is called tax effort. But the Finance Commission doesn't stop there. It again multiplies this ratio with 2011 population. And why? Because it wants to see The argument here given by the Government Finance Commission is that they want to see that how much improvement has been made with respect to the current population in the tax efforts. Again, the same problem. Under the 2011 population, of course, the states with higher population, due to the multiplication factor with the tax effort, it will lead to higher parameter, higher result. And therefore, southern states are at a disadvantage in this regard also. Now here, I have just a few more things. Yeah. Now here we go back to our earlier point about which southern states, and I know this question will come, so I'll say it right now. Here, but still, thank you. Here we go back to our earlier point about which southern states are expressing their concern, which is this: since they contribute more to the tax pool, they should receive more. That is the continuous argument which the southern states are making. This argument is on the felt unfairness in the distribution. And it should not be mixed with the role of the Finance Commission. That is not the role of the Finance Commission to see who is giving how much. We look back, and also we have to see that if we look back, we'll find that the states which are contributing more to the tax pool today have already started from an advanced position. Therefore, as I stated above, the role of Finance Commission is to ensure fiscal stability and fiscal equalization. So this, and therefore at this juncture, it is important to highlight it being in a federal nation. Federal solidarity and federal cohesion has to be also respected. One cannot always have its fight on the grounds of fiscal autonomy, and we have already covered the pointers which are there with respect to fiscal autonomy. But both the issues should not be conflated here, and fiscal solidarity also has to be respected. I'll pause here. So in conclusion, the balance between fiscal stability, tax devolution, and autonomy is fragile and complex. For fiscal federalism to truly work, we must ensure that states must have control over their resources, fair representation in the transfers, and at the same time, the ability to make decisions and to best reflect the unique needs. Thank you so much.
Thank you, Pankhodi. I think the most important takeaway is firstly just the sheer amount of information that I was not aware of when it comes to fiscal relations between the union and the state. And the second more important thing is that we don't conflate ideas of fiscal autonomy as against fiscal fairness, which is a question of allocation. These are two different things and that require different means of addressing it. Our final panelist is Sohrit Parthasarathy, who is an advocate at the Madras High Court, and he's going to take us through the two judgments that deal with alcohol and mining.
Sure. Yeah, good afternoon, everyone. It's great to be back here. I think I can be a little more optimistic in terms of my address and in terms of how my address goes. I think there are two judgments which I'll deal with, two judgments of 9-judge benches. One is State of UP versus Lalita Prasad Vaish, which was decided in October of 24. And the other is Mineral Area Development Authority versus SAIL, which was decided in July of 24. They deal with two entirely distinct issues. And they do, however, concern with some of the minutiae which is contained in Schedule 7 of the Constitution. So we'll have to sort of dial back a little and try and understand how the division of powers is made under the Constitution. I understand that some of you are first and second year students and might not be entirely familiar with the text which these judgments deal with. So what I'll do is, before diving into those judgments and what they hold, I'll just give you a very, very quick sort of primer on the constitutional division of powers between the union and the states. For those of you who are deeply familiar with this, you can choose to sort of ignore this, but this is more for the benefit of those who've probably not read those parts of the Constitution. So now, Article 246 is the provision in the Constitution which deals with subject matter of laws made by Parliament and the state legislatures. 246 essentially says, and I'm not going to read it, that whatever subjects are contained in list 1 of schedule 7 of the constitution, it is parliament alone which will have the exclusive power to make laws on these subjects. 246 also says that subject to this power that is vested in parliament, with respect to those entries that are contained in list 3 of the 7th schedule, which is popularly known as the concurrent list, it is both the parliament and the state legislature which will have power to enact laws. Now, of course, if there's a conflict between the two laws, which are made from the concurrent list, it is the parliamentary law which will prevail, subject to the caveat that a state law can prevail if it is expressly reserved and secures assent from the President of India. Now, insofar as those subjects which are contained in list 2 are concerned, what 246 says is that subject to both of the other powers that I just mentioned, it's the state legislatures alone which will have the exclusive power to make these laws, to make laws which are contained in list 2, which is known as the state list. So this is the broad delineation of power that is made under the constitution. And as you can see, it's heavily tilted towards the center and towards the union government. And historically, the way the Supreme Court has interpreted many of these contests that have interpreted these provisions in the context of many of the battles that have come up before it has been by largely giving the constitution a unitary tilt, and which is why many of you may be aware of this. India is often described as a quasi-federal state and not as a purely federal state. But these two judgments that we will look at today do somewhat depart from this notion. They depart from this idea of India being a purely quasi-federal state and do try and give particular meaning and emphasis to entries that are contained in the state list, with a view to ensuring that those entries aren't rendered otiose by an exceedingly expansive reading of other entries contained in the union list, which tend to sort of ensure that even those entries that are expressly reserved for the state legislatures often tend to get overridden. We'll first look at the judgment in the Mineral Area Development Authority case, which, as I mentioned, is a 9-judge bench decision. Both the judgments, both the majority opinions in both the cases that we'll be discussing today were delivered by Chief Justice Chandrachud, and I'll broadly deal only with the majority opinion in the interest of time. The question in the mineral rights case broadly dealt with whether or not the state governments have a power to tax mineral rights. The judgments that had preceded this, especially a judgment of a 7-judge bench in India Cements, effectively held that state governments had been divested of these powers by virtue of a reading of various entries in the various lists that I've just mentioned in Schedule 7 of the Constitution. Now, to understand these judgments a bit better, we do have to kind of read a little closely the entries contained in the list, and that is unavoidable, so let me do that. We're concerned here with entry 50 in list 2, entries 49 and 50 in list 2, in fact, entry 54 in list 1, and entry 23 in list 2. Now, entry 54 of list 1 says, regulation of mines and mineral development to the extent to which such regulation and development under the control of the union is declared by Parliament by law to be expedient in the public interest. So therefore, if there is a particular law that the Parliament wants to bring in public interest to regulate mines and mineral development in any part of India, it has the exclusive power to do so by virtue of entry 54 of list 1. But now look at entry 23 of list 2. Entry 23 of list 2 says regulation of mines and mineral development subject to the provisions of List 1 with respect to regulation and development under the control of the Union. So which means that the state government also has an exclusive power to regulate mines and mineral development, but this is subject to the power that is expressly vested in Parliament under Entry 54, which then means that so long as Parliament has brought about a law in public interest to regulate mines and mineral development, the state, at least under Entry 23, will not have the power to make a similar law. There's no question in this case of bringing about a law and then securing the president's assent and so forth, because these are entries contained in the state list. But Entry 50 of the same state list speaks of taxes on mineral rights subject to any limitation imposed by Parliament by law relating to mineral development. So the taxing power with respect to mineral rights has been vested through Entry 50 in the state governments, subject, however, to any imposition that Parliament may, by law, make with respect to mineral development. And Entry 49 of the same state list simply says taxes on lands and buildings. Now, in this case, what had happened is there was a Mines and Minerals Development and Regulation Act of 1957, which is a parliamentary law. Now, this law in Section 9 provided for the provision of royalty. It broadly said that the holder of a mining lease shall pay royalty in respect of any mineral that is removed or consumed from the leased area at the specified rates. So therefore, Parliament through rules could prescribe at what rates these royalties would have to be paid. And any person who is a lessee who holds a mining lease will have to necessarily pay royalty whenever the industry consumes any mineral or extracts any mineral. Now, the Section 9 is silent on whom this royalty is paid to. But in practice, this royalty can be paid either to the state government or to the central government, given whoever is the holder of the property, whoever is the owner of the property, or it could also be a private lessor. Many private lessors would hold lands from which minerals can be extracted. And if there is a lessee on those lands, then those lessees would have to pay royalty on that to the owner at rates that are prescribed by the government. So this is what Section 9 broadly prescribes. The question, therefore, which was framed is this royalty, which is determined under Section 9, in the nature of a tax? And if it is in the nature of a tax, and if it is governed under Entry 54 of List 1, are state governments entirely divested of their powers to bring about any taxing legislation on the consumption of minerals? The earlier judgment in India Simmons, as I had mentioned, did hold that Section 9, the royalty that is prescribed under Section 9, was in the nature of taxation. And therefore, state governments were entirely divested by virtue of the fact that the concerned entry in List 2, as we said, subjects itself to law made by Parliament. So this was the chief question that the court in mineral area development had to answer. Now, in going about deciding this question, the court had to see how it had to balance the two powers that were vested, one in Parliament and one on the state legislatures. Now, there's the locus classicus on this, which is Hearst Pharmaceuticals versus State of Bihar, a 1983 judgment, which delineates a number of principles. It says, for example, that Parliament has the exclusive power to make laws with respect to matters enumerated in List 1, as I mentioned. That the non-obstante clause, that is the use of the words notwithstanding anything to the contrary, which is contained in Article 246(1), ensures that there is predominance and supremacy that is vested in Parliament. That the legislative powers of the Union legislature, that is the Parliament, is not encumbered in any way by anything contained in clauses 2 and 3 of Article 246. That the state government nevertheless has exclusive power to make laws with respect to all those matters that are enumerated in List 2. However, that the exercise of this power will be subject to any law that is made by Parliament under 246(1). So therefore, the upshot being that in the event there is a conflict between an entry in list 1 and list 2, which is incapable of reconciliation, the power of parliament must prevail and must supersede. This is the broad holding in Hearst. But this also has to be seen in the context of another holding of the Supreme Court in another famous case in MPV Sundarama Iyer, in which the Supreme Court essentially said that there's a distinction between general entries and taxing entries. Now, in the case of a general entry, you could potentially have a situation where a power is vested both in Parliament under List 1 and in the state governments under List 2. For example, we saw already in entry 54 of List 1 and entry 23 of List 2, the power to regulate mines and minerals is given both to the union government and to the state government under List 1 and List 2. But insofar as the power of taxation is concerned, it's almost always exclusive. There can never be an overlapping of powers. So the Supreme Court had to look at this power to tax that was granted under entry 50 of List 2 in the context of these various judgments. And what the Supreme Court did, and I think this is really possibly for the first time that the Supreme Court took this idea really seriously, this idea of fiscal federalism. And the fact that you have two distinct autonomous units operating within their respective sovereign realms, being allowed the capacity to tax India's citizens. And when it looked at it in this context, the court first decided, and I won't belabor this point, I'll have to move over to the second judgment as well, just to give you a broad overview. The court concluded that the royalty that was prescribed under the MMDR Act, which is the 1957 legislation, is not a tax, but is merely in the nature of compensation for services that are rendered. Now, so for example, anybody who extracts a mineral or consumes a mineral would have to necessarily pay royalty to the owner of the property. And this is not in the nature of tax. This was the final conclusion of the Supreme Court. When it came to examining the relationship between entries 23 of List 2 and entry 54 of List 1, what the court did was it formulated the discussion in the following manner. It said that the state government has the exclusive plenary legislative power with respect to whatever is prescribed under entry 23 of List 2. But entry 23 of List 2 is subject to entry 54 of List 1. And therefore, it cannot make a general law with respect to regulating mines and development of minerals. But insofar as the power to tax under entry 50 of List 2 is concerned, because this is an exclusive power, it is a power that vests entirely in the state legislature, and the union government cannot proscribe this power in any manner. And the taxable event in this case would arise when, with respect to the taxes, will be on the exercise of any of the mineral rights. Now, the caveat here, of course, that the court added was that Parliament can always determine by law how the taxing power of the states over mineral rights should be limited in order to ensure that it does not impede or retard mineral development in any manner. So the final conclusion being that the power to tax which arises or emanates out of entries 49 and 50 of List 2 is exclusively vested in the state government, subject only to the caveat that I mentioned. And the power that is otherwise exercised by Parliament under entry 54 of List 1 does not impede the state government's power to tax in any manner. I'll just quickly move over to the second judgment, which is State of UP versus Lalta Prasad Vaish, which was decided in October last year. This judgment wasn't as much about tax as it was about the ability of state governments to levy fees and other charges.
Hi, sorry, it's gotten muted. Can someone just... Yeah, no, it's back. Thanks.
The question here was whether intoxicating liquor in entry 8 included only potable alcohol, that is, alcoholic beverages which were meant for human consumption, or it included other production of other alcoholic products as well. Now, once again, the Supreme Court was facing a judgment of a 7-judge bench in synthetics and chemicals, which had effectively ruled that entry 8 only dealt with alcohol that was meant for human consumption. The entries that we'll broadly have to look at here, and I'll just very quickly go over them, are entry 52 of list 1. I'll just take 2 minutes to wind up. Entry 52 of list 1 deals with industries, the control of which by the union is declared by Parliament by law to be expedient in the public interest, very similar to the other entry that we saw in the case of the mineral matter. Now, in this case, by virtue of an exercise of power under entry 52, Parliament had by law declared the industry of alcoholic production to be a law that needed to be regulated by Parliament in public interest. But on the other hand, you had entry 8 of list 2, and entry 33 of list 2, which also had to be looked at. Entry 33 of list 2 basically says trade and commerce in and the production, supply and distribution of the products of any industry where the control of such industry by the union is declared by Parliament to be expedient in public interest. The question is now, no doubt, when a law is declared to be, when an industry is declared to be an industry that has to be governed by Parliament by virtue of an exercise of power under entry 52 of list 1, would it in some manner denude the state of its powers under entry 8 of list 2? What the Supreme Court did was it carefully considered the scope of these two entries and said that entry 8 by itself indicates that the intent of it is to ensure that it is read as broadly as possible. The entry covers production, manufacture, possession, transport, purchase, and sale of intoxicating liquor. And it uses the words intoxicating liquor and not potable alcohol. And therefore, it has to be read in a manner as widely as possible to include all manners of liquor, which are not just meant for human consumption, but also for other kinds of industry as well. In the interest of time, I won't go into a broader discussion on this judgment, but by so holding, what the court effectively did was to give a sort of a fillip to fiscal federalism and to the idea of states enjoying greater autonomy in being able to generate revenue through not just taxation, but through the levy of fees, cess, and other kinds of levies as well. Thank you.
Thank you, Sorit. Just an observation that a clear part of the crisis is the state's ability to generate revenue for their increasing expenditures. Unlike previous judgments, these two at least give some leeway to states to generate revenue, especially in light of the fact that GST actually takes away a lot of the local bodies' sources of financing as well. Before we open it to the audience, if the panelists would like to respond to anything that has been spoken about, we have some time, so we can do that. Alok.
I just have one very quick point. I think to add to what Surat just said, I think this is something which is worth a longer book, which is to see how the Supreme Court's jurisprudence on taxation powers of the state have liberalized, or not liberalized, let me say, become tilted more towards the state in the last 20-30 years. And the best example that I could think of was again from a few years ago, Jindal Stainless, where they overturned 50 years worth of jurisprudence to say no states do have the power to impose entry tax. Now, it came a little late in the day because GST had already taken over by the time this judgment came into effect. But in terms of the discourse, I think it will be fascinating to compare and see how judges in the past approached questions of state taxing power versus judges in the last couple of decades approaching the questions of taxing power. And I think, and this is my hypothesis subject to somebody else, there has been like a 180-degree turn. Not just in terms of the outcomes of interpretation, but just in terms of the constitutional understanding or the court's understanding of the constitutional position on federalism has undergone a dramatic turn. And I think the judgments that Surit discussed kind of go along that trajectory.
Thank you, Alok. Surit, is there something you'd like?
Yeah, I just want to say that one of the things that the Supreme Court did do in Lalta Prasad Vaish, and I think this is a very important thing, was we saw the judgment in Hearst, which spoke of where reconciliation is impossible, the power of parliament would have to prevail under list one. But the Supreme Court here held that this reconciliation is to be done when after you've interpreted the scope of the entries in which the competing entries in list one and list two. At that stage, when you find that there's an overlap and it's impossible to in fact reconcile the powers, then it's the entry in list one which would prevail, or it would be Parliament's law which would prevail. But the reconciliation should only happen at that stage. At the stage of merely seeing what in fact the entries cover, you should give the widest possible interpretation as possible. And not with a view to avoiding reconciliation, so much as ensuring that you give it the widest possible meaning and then see whether it's incapable of reconciliation or not. Because otherwise you'll effectively be tilting the federal balance towards the union at an unreasonable level.
Thank you. We can have questions from the audience now. Yeah, Archita.
Hi, this question is for Suraj sir, but also for the panel in general. I think it also relates to what you just mentioned. The MADA case does a really interesting thing in the majority, but I think.
Speak into the mic.
Hello. Yeah. So I think the MADA case does something really interesting compared to the Hoist Pharmaceuticals judgment, which gave us a sort of blanket application of parliamentary supremacy when there's conflict. But MADA goes on to say that when you're reading entries, you have to see whether they really are subject to sort of parliamentary powers. Do you think that will help the state autonomy angle in the Supreme Court reading that further in future cases?
Yeah, I think certainly it would help. And you're very right in pointing out that MADA also does this. And in fact, both the judgments do get into a discussion of Hearst and in terms of how it can be applied in a manner which would advance fiscal federalism. But it also sort of really depends on what we look at as the objective of constitutional interpretation is, right? Because if we wanted to go by the traditional view of saying that our constitution is quasi-federal and therefore we must interpret the constitution in such a manner which favors a greater balance of powers lying with the union, then you're likely to read things in that manner. Whereas, as Alok mentioned, there has been a slow sort of shift, especially over the last decade or so, towards ensuring greater state autonomy on certain matters. And I think we should begin with this. I mean, it's indisputable that on a bare reading of the Constitution, the powers are tilted towards the union, which then I think calls for a different, at an interpretive role, then it calls for a different sort of approach from the courts, right? Because the power is tilted towards the union, wherever powers are expressly vested in the states, you must give it the widest possible meaning, because otherwise you're leading to a different kind of crisis. So therefore, and I think these two judgments they're very conscious of that sort of a reading. And you can see that especially in the discussion in MADA from paragraph 48 onwards, where there's an express section on fiscal federalism, which also deals with Mohit Minerals, which presumably the conference would have dealt with last year, which is also an important judgment on, but which hasn't really been applied thereafter, but which at least in paper remains an important judgment. Yeah.
Pankuri, the question was to the panel if there's something you want to add. Alok?
Just to, and I was going to mention this, and since Sudhit has brought it up, I think Mohit Minerals lies like a landmine in our constitutional tax jurisprudence. The circumstances haven't arisen, nobody has put a foot yet, but I think it creates possibilities for a very serious unraveling of the GST mechanism if its interpretation on GST regulations, the GST recommendations not being binding, is taken very seriously by some states which decide to pick a fight when the moment is right. It could potentially upend a lot of our thinking on GST and fiscal federalism. So I'll just leave it at that.
Yeah.
center-oriented approach of the code, that any limitation can include prohibition and every limitation possible. So it can constructively restrict the state from imposing any kind of taxes upon mines and minerals.
Wanted to add a line here that it's a very right observation that by the like even though the judgment is started with all that positive note and optimism here with respect to fiscal federalism, and it's a commendable judgment. But yeah, while we reach to the end of the judgment, yes, it uses the word prohibitive, and that's where it leads to that kind of confusion, and later the case might be revisited in that regard. Yes.
Well, I think we don't know yet if there would be a law that's made by Parliament naturally, which entirely prohibits the levy of tax. But even such a law would be subject to other kinds of challenge, because under entry 54 of list 1, it would necessarily have to be something that is in public interest, right? Like, I mean, because a law under entry 51 would have to be declared by Parliament to be expedient in public interest. So if a prohibition of that sort of taxation altogether, and I'm just sort of thinking on the spot a little bit here, is not seen as something that is necessarily expedient in public interest, and the law doesn't, and therefore the law cannot really be seen as something that is in furtherance of entry 54, then the power under entry 49 and 50 would remain. And also what's interesting in the royalty ruling, it's only entry 50 which is subject to law made by Parliament. But if you look at entry 49 is not subject. Entry 49 simply says taxes on lands and buildings. And this was not something that was originally a part of the reference. But they do hold that even for the mere use of land, etc., on which mines are extracted from, the state governments will have the power to tax. And this is not something that has been exploited by the state governments yet. So I think on the one hand, as you point out, maybe there's something that could be seen as potentially taking away from state powers. But at the same time, there's also a grant under entry 49, which remains for the state governments to suitably exploit. So I think the fact that entry 50 is subject to limitations imposed by Parliament by law relating to mineral development is no doubt true. And if Parliament were to entirely proscribe or ban taxes, then the question that you say would arise. But Parliament cannot in any manner restrict taxes on lands and buildings, which includes taxation on lands from which mineral is extracted. So in that sense, I think that balance would be maintained.
Yeah, Shamil.
So my question is to Surit sir. So with respect to, like, while again the judgment in MADA was facilitated by the classification of royalty not being a tax, and then again the entire dispute did not arise. But hypothetically, let's say the court did not arrive at that conclusion, and both were in fact considered taxes. Then would let's say a theory such as the double aspects theory be useful here to uphold both the aspects of taxation?
No, I actually think that the court would not have come to a different conclusion. What would have happened is Section 9 of the 1957 Act would have been subject to challenge if it had been in the nature of a tax, because the union would never have had the power to tax, because the power to tax has to flow from the relevant entry. If that power to tax was absent, then that legislation would have been separately amenable to a constitutional challenge. And which is why I think it makes sense to hold that royalty can, because which is also a reason why India Cements was incorrectly decided. Because if royalty is construed as tax, then it could not have been attributable to any of the entries in the union list in the first place. And which is why I also mentioned MPV Sundaramaiah, which is that as far as taxing entries are concerned, you can never really have any overlap.
Any other questions?
Yes, I have a question which is slightly different actually, in the sense that while discussion around federalism is confined to 7th schedule, the 3 lists and Article 246, before that comes 6th and 5th schedule. And a bare reading of them suggests that the 7th schedule, application of 7th schedule is not automatic in the 5th and 6th scheduled area. But how do you understand, even in the classroom or this kind of conference or even in the court decision, the absolute absence of the perspective of fifth schedule and sixth schedule, which were annexed to Union of India in 1950 or around that period, with a promise of autonomy, absence of fiscal federalism, or the flow of cash, or the sharing of it with the fifth and sixth schedule area and their autonomy in that respect.
Yeah. I think Alok is best placed to answer this.
That's a great question. And I think some of it has to do with the idea that fifth and sixth schedule were not supposed to be putting Adivasi areas at exact par with state governments. Again, if you see historically, the level of, for the lack of a better word, development, and now I think the correct term would be state capacity. I don't think that that intent was that these areas which had never exercised the kinds of powers would be able to exercise them in the context of the fifth and sixth schedule. Uh, there is, however, an interesting argument to be made, and I think this is where a lot of our conversations we mentally, create these categories which I'm not in favor of, where we say federalism is just about center and states, right? We've just replaced one topic of center-state relations with federalism. But if you honestly ask me, and you're absolutely right, federalism should account for all the other subnational arrangements, that we call it that Indian constitution provides for. And it includes everything from the panchayat to the municipality to the Zilla Panchayat to the hill councils and the development councils, all those various subnational governance arrangements, which frankly aren't fully theorized, I think. I think we are still understanding the meaning and implication of having fifth and sixth schedule area. See, they were seen as fifth and sixth schedule areas in the constitution, right? We haven't yet seen them as sufficiently independent, sufficiently functioning governments. And in that sense, I absolutely get the point, and I think there is a need to reconceptualize that maybe Indian federalism has more than just two steps, center and state. That there's probably center, state, district councils, regional councils, hill development councils, and all these other entities. And maybe we need a more nuanced understanding of what kind of powers, what kind of resources these agents of these governments need to function. Because somewhere in our heads, we only see the union and state government as government, and everyone else as just a sop to some local people to keep them happy, which is, I don't think, the constitutional vision at all.
Thank you, Alok. Anything else? The mic isn't working.
My question is to Alok, sir. While the objective of maintaining fiscal discipline is unquestionably important, the means employed by the FRBM Act and its amendment by the introduction of general government debt, which effectively brings state borrowing under the control of the union, despite state debt being a distinct entry under the state list. Given that Article 293 already provides a framework for union control in specific cases, don't you think the legislation from which the center is deriving its authority to impose such a borrowing cap on the state of Kerala represents an overextension of central power, undermining both the principle of federalism and the balance envisioned in the seventh schedule of the Constitution?
Again, great question. But UCC 293 provides for state union control of state debt, and it's law made by Parliament. Now, in this context, this FRBM is both under 292 and 293. It also controls the union's own debt-taking power. Like I mentioned, for the longest time, there was no legislation which controlled the executive's power to take debt, and Ambedkar sort of mentions in the Constituent Assembly, like, I don't see why anyone should question how much debt the union should take on this point. And again, keep in mind, there was, while of course everywhere we say law made by Parliament, it's somewhat unrealistic for Parliament to impose a certain kind of check on the executive, and the executive itself draws power from Parliament. The executive has so much power in relation to the Parliament as well. So we have this Westminster form of democracy that perhaps is not the best check on the powers of the executive to take debt. Having said that, I think because, like I said, there is a coming crisis, and before we get to that crisis, there is a need to re-examine this particular arrangement. And this arrangement being, how do we balance these two values, right? To kind of, and I see that our constitution is in a way always trying to balance two values, because otherwise if everything was straight and clear, if everything was about just one thing, we won't need so many rules, we won't need such a detailed constitution. Here we have to come to balancing two values, right? On the one hand, you need to be able to have some kind of fiscal discipline where it's an element of intergenerational equity, right? It's an element of intergenerational equity where one generation does not burden the coming generation, which has had no say in the taking of debt, with enormous taxes, with a weakened economy, with less access to credit, simply because it suited our generation, right? That is one thought. But the other thought, of course, is that there are current needs as well which need to be met. That how do you ensure that states and federal principles which underlie our constitution do not get undermined simply because we say that no, we shouldn't burden future things. So this is a balance which is to be drawn. But and maybe the balance which was created in 1993 needs to be re-examined back in 1950. Needs to be re-examined given how the economy has changed, given how the budgets have changed. I mean, I was recently at a conference where, people who have seen budgets for much longer years are find it very hard to believe the size of state budgets anymore. And if you go back and see some of even the 90s, right? Forget about 50s and 60s, even the budgets in the 90s, you will see how the resources available to a state have grown exponentially. And in that sense, perhaps, maybe this was not what constitution framers had even imagined would be possible. And constitution is always a flexible document. So you're right to the extent that we may need to re-examine this mechanism, but we can't do away with this need to strike a balance. And that balance cannot be that we enforce federal principles at the cost of wrecking the economy 10 years down the line. By the way, before I finish, I didn't have time for this. For those of you who are fans of the musical Hamilton, please do check out Cabinet Rap Battle #1. You'll know what I mean.
Question regarding fiscal federalism. Like in the recent perspective of the Indian government, reduced the state share of federal tax revenues from 41 to 39%, or 40% if I'm not wrong. So now the question is, how we can expect a balance between the union fiscal responsibilities and state fiscal responsibilities to ensure a fair development in the Indian nation? So how can we expect a balance between the union fiscal responsibilities and the state fiscal responsibilities to ensure development and growth in the Indian nation?
Yes, so the change which has been made is 42 to 41%. So 1% change has been there, and because now J&K is part of that, situation has changed. So with that is what, in fact, the question which you are raising, that is forming the crux of the conference, this panel itself, that we already know that there is function resource mismatch, in the sense that center is, while liable for only around 37% of the expenditure, states, if we just visit list 2 or under schedule 7, then the states have responsibilities which will require around like 63% or somewhere, it's like that skewed ratio is already there. So we understand that the union is getting more taxes, but it has to spend less, while states have to do the opposite. That balance has to be reached, and for the purpose of balancing only, we have that independent intergovernmental body constituted under Article 280 of the Constitution, which is Finance Commission. And earlier we had Planning Commission as well, but now we have moved away from that kind of system. So Finance Commission has two powers. It recommends basically on two grounds, that since the union has larger share of powers, larger share of taxation powers, therefore Finance Commission takes some part of the central taxes and give it to the states. That is how the balancing is done. And secondly, after this balancing on this ground with respect to the tax transfers is there, second role which Finance Commission plays is with respect to the revenue fiscal deficit grant. It means that, let's say, if I am a state and I ask for 100 rupees for this month, and even after the transfer from the center's taxation pool, I'm only getting 40, but I need 100, right? So 60 is my revenue deficit. That is my expenditure deficit, which I need still, right? So obviously the whole 60 will not be given by the Finance Commission as grants to me. Some part of it will be given, and that is centrally sponsored schemes and central sector schemes, which are the different ideas. So this is how the balancing, which we are, the question, if I understood correctly, is about the balancing. And this is how balancing was supposed to be done. The problem is that when center interferes with the Finance Commission's terms of reference, that you grant to the states. Let's say this time center has come up with the afforestation program, that there should be more plantation of more trees and etc. Then politics, federal politics also get involved, and center may also start saying to the Finance Commission that forest cover can be taken as a criteria for the purpose of devolution. In that way, the favoritism and all kinds of interferences come. So that is what we are trying to highlight, that balancing institution is supposed to be, that balancing component is supposed to be maintained by the institution of Finance Commission, and let that Finance Commission to operate freely.
Thank you all.
Just quickly add one point, I think, in closing. Even this particular aspect, and I think the last point that Pankuri made, in a sense, and this is what more and more research is showing, it's actually not disadvantaging the better off states that much, because they have better state capacity. If you would just take afforestation, a state which has a much more extensive forest bureaucracy, like let's say Tamil Nadu or Karnataka or Kerala, will have great afforestation efforts, as opposed to say a state like Bihar or Uttar Pradesh, where the efforts may not be as good. So even though you are trying to find ways to transfer money to poorer states, what is happening is that still the better off states are still being better off. And perhaps this therefore suggests that why are we bargaining on the edges? Why are we saying take 10 rupees from Bihar and give to Karnataka and vice versa? Why can't the pool for the state governments itself go up to 60-70% or 60% of the expense on human social welfare very broadly is happening at the level of the state governments? Why doesn't the Finance Commission just transfer 60% and then draw up the boundaries within that, make that horizontal division within that? So I think this is the larger question, and I think this is the more bolder question that we should ask. Why are we tripping over 41, 42%, half a percent here, half a percent there? Why does the Finance Commission just not say take 60%? The implication of that will be that a lot of union ministries will have to shut down, and that perhaps is not acceptable to any union.
Thank you all for joining us. Thank you, panelists. This was a very informative and instructive panel, and I hope we can take the conversation forward after the session. Thank you.
Thank you. Thanks, everyone.
Can the students just stay back for a moment, like before leaving? I think panelists and faculty can leave before, so that it's much more organized. And first and second years are requested to leave from this podium side. Third year, fourth year, fifth year, and LLM from that side.
performing artist can keep the crowd till the end is the one who comes last. I want to believe so, though I know that's not what has happened. I also sort of feel that this panel is a cause of, should be a matter of great pride for all people at Nalsar, because this judgment is driven by a report which came from Nalsar. And I think it's important, it's not necessary all of the time that one has to downplay one's own work. One should sometimes even come forward and admit to it. Having said that, I also want to make it clear that this judgment has done amazing thing for the rights of people with disabilities. It's moved accessibility away from a kind of symbolic tipping of hat to making it a reality. It's saying that you don't have to talk about accessibility as just retrofitting, but from the very inception, every kind of infrastructure that you create must be accessible. It's also emphasizing on the fact that accessibility is for all disabilities, whether included or not included within the Disability Act. It's also saying it's for all parts of the country, rural, urban, whatever kind of geographical, geographical terrain you may have, you have to think about accessibility. Having said all of that, that it's doing for the rights of people with disabilities, I want to make it clear that this panel is not going to talk in terms of what it has done for disability rights. Instead, what the entire panel wants to focus upon is what this particular judgment has done for constitutional rights. What has it done for constitutionalism? I mean, it's because it's a Courts and Constitution conference, it was important that we kind of make that very integral connection between the pronouncements of this judgment and how it feeds into constitutionalism. So I would say there is a text of the judgment and there is a subtext. What we plan to do is somewhere draw out or foreground that subtext for you. What it is doing in terms of when it's talking in terms of accessibility, what exactly does accessibility mean? Is it only accessibility for people with disabilities, or is it accessibility for all persons? What has it done in relation to equality? What has it done in relation to sexual citizenship? And lastly, what is the kind of discourse this judgment is inaugurating on participative lawmaking? So each of the panelists are going to take this theme around. We're going to begin with Nilesh Singhit, who's the Distinguished Fellow at the Center for Disability Studies, who's going to talk in terms of the accessibility dimension of the judgment. Accessibility, like I said, of course, what it has done for the rights of people with disabilities, but more importantly, how it is saying that accessibility is a right for all, including persons with disabilities. The moment you start speaking in that manner, the emphasis or what you should see in this judgment starts to change. So Nilesh, can you begin the conversation for us?
Good afternoon. Am I audible? Yeah. Thank you very much, Dr. Danda. First of all, I would just go with the caveat that I am not a lawyer. So whatever I speak would come from my lived experience. And as a person with disability who's been doing access audits for a long time. So I'll just go back, say around 20 years ago, 25 years ago, when the first PILs were actually coming into being filed in the various courts. And one of the PIs that I was involved with was the BST buses, the buses in Bombay. And at that time, I mean, accessibility, even the courts actually looked at, is something that a person with disability requires, and it's just doing a favor. So one of the orders that they gave was 3% of the buses were made disabled friendly. So out of 1,000 buses that were being bought, only 3% was made. So the entire, the premise was the 95 Act within economic capacity. I mean, if we don't have the money, and we did not have the money, so whatever we give you, you better take it. That has been the kind of thing, and slowly, progressively, that thing was struck down, saying that accessibility is important. So when the next PIL on the railways was filed, they kind of made it that it was disability was mandatory. But unlike the Rajiv Rathuri judgment, it was never the fundamental right. It is something that you require, and we'll see how we can provide it. I mean, what are the various ways we can provide? So slowly, I think, various guidelines were made. There was one guideline by the Public Works Department. There was one guideline by the Disability Commissioner's Office. And then slowly, everybody made up their own guidelines. So one of the things that the Rajiv Rathuri kind of PIL strikes down is that guidelines are only recommendatory. They do not have any power to kind of get it done. So we need basic floor accessibility, minimum requirements, non-negotiables. So I think we are, while we're drafting the rules, we would kind of make it more evident as to what they are and will translate into something that, would be drafted later by. But that is the kind of thing that has been going on. Accessibility, one must understand, as it's a fundamental right, it affects everything that a person with disability does, right from cradle to grave. I mean, you get up in the morning, you have to have your room accessible where you can actually, with dignity, go, brush yourself and do your daily, routines. Bathrooms has to be accessible. Then transport is very important. Transport kind of leads to a lot of other things, saying if there is no transport, you cannot go to school, college, you cannot go to work, you cannot do any other thing. Accessibility, really kinds of, is a cornerstone. Article 9 of the CRPD recognizes that, and this UN CRPD kind of has this twin track approach. And Article 9 talks about accessibility, but at the same time, when every other issue is addressed, say education, employment, again accessibility is spoken of, so that nobody kind of misses out. It just not gets lost in the jargon and the things that lawyers are best want to do. That you find something and not do about it. So there is no scope to kind of the Rajiv Rathuri judgment kind of really Article 21 of this Constitution, right to life, it recognizes that, saying that if you have accessibility, only then all these things are possible. After all this, there was this whole kind of a fad with everybody, get access audits done. I can name institutions which have got it done for 3-4 times. I think even in Nalsar, our access audit is still pending. We've still not worked on it, to get it done. So we need to kind of really push. These audits are done, but unless you translate it into something meaningful, I think nothing really turns out. You're just rhetoric that is there. Accessible, this entire case, it goes beyond rhetoric. It's time to kind of things to put it in action and see how people with disabilities can do a lot of things, because accessibility has been done. Then there was multiple guidelines, kind of has its own cacophony. You really don't know what to do. I think we need to really, that is going to be struck down anyway. And accessibility, it's not just physical accessibility. I think ICT accessibility, right to, personal relationship, which I think Abhishek is going to later speak about. Even that was kind of, looked at, which usually nobody even thinks about it. I will not kind of encroach on Abhishek's thing, but just to make a point, our lives are so dependent on others. Nobody even thinks that, I can have a personal life myself. So those are the things that, were done. I think another thing is right to vote. This is not part of the Rajiv Rathuri PIL, but that was the actually set a lot of things ball rolling, because right to vote comes under your civil political rights, accessibility, and your social rights. But the Bombay High Court at that time understood that without accessibility, you can't vote. And that is something that really gives people the power, to be recognized. And census is still not done. And I hope they kind of do the census. So we really need to kind of find how many people with disabilities are there, and you know, and see, I mean, you know, how we can, I mean, you know, do a lot of things for it. Yeah, thank you. I mean, if you have any questions, I'll.
Stressing on the fact this particular judgment is free rights. So what I want you to take note of here is primarily this, that accessibility at one level could be seen as a social economic right. But you have, if you don't meet this right, all your civil and political rights are also denied. So the very fact that Rajiv Raturi sort of said that accessibility is a precursor, is a prerequisite to all rights, it's a cross-cutting right, it has in effect made this question of civil, political, and social economic rights as indivisible. And this indivisibility, which has come in relation to persons with disabilities, can be stressed upon by all communities which have a similar kind of need for looking at civil, political rights and social economic rights together. You can't think of one without the other. And it's also, I mean, and I think that's a very critical part of what this judgment is doing. I wanted to stress one more thing, that it's talking in terms of, I think at least 3 or 4 times in the judgment, it says accessibility for all persons, including persons with disabilities. So it is speaking about accessibility as required by all people. You can't talk about freedom of movement without having, you know, whether it's transportation or roads or, you know, like the places where you can move from. If you remember, as far back as in Umesh Singh versus state of Himachal Pradesh, when you spoke in terms of not having a road in a hilly area is actually denying the right to life and liberty. It came in somewhere in the 80s. I think from there, if we look at this holding of accessibility as a fundamental right in Rajiv Raturi and think of it as being speaking for all people, definitely for people with disabilities as the primary constituency, but not as the only constituency. And I suppose for me, the thing on which I'm going to reiterate virtually after every panelist is look at the possibilities of this judgment for every excluded group. And we've always, I mean, it's a slogan, at least in disability, you know, like disability circles, that's what's good for disability is actually good for everybody. And if you are starting to think in terms of making an accessible world, and if you start seeing what all we are putting into accessibility, you start to see what is happening with this judgment and why it needs to be engaged with not just by disability studies or disability rights scholars, but by all of us who are concerned with constitutional rights. I'm moving from here to invite Amar Jain, who's our next speaker, and who's going to sort of focus on how this judgment has in some way broadened our understanding of equality and inclusion, and what is it that the court has done here which can again be drawn upon and borrowed from by other constituencies. Amar is a practicing advocate in the Delhi High Court, and he's also with Mission Accessibility. He's done some really rocking cool work in the whole area of IT communications, but as such, he's an amazingly cool person. Come on, Amar.
Thank you, ma'am. If we look at our constitution, and I'm specifically referring to part 3, which is fundamental rights, we are focusing on 2-3 key aspects. One is equality, second is freedom, and third is your right to live life with dignity. And Rajiv Raturi as a judgment, what it did first, it traced international obligations and international discussion around accessibility. It referred to the United Nations General Assembly resolutions passed in 1982 and 1993, moved on to UDHR, ICCPR, and then came to the Bible of disability rights, as we call it, UNCRPD, right? United Nations Convention on the Rights of Persons with Disabilities. In the I also then looked on the international jurisprudence, either by the Court of Hungary or in European Union, and various other jurisdictions. And in all the discussion so far, it found that equality and accessibility go hand in hand, in a sense that accessibility becomes your mandatory requirement to be able to achieve what this judgment calls it as a substantive equality, not just formal equality, right? So then it went on to discuss the Indian case laws around, accessibility, equality, how it is part of, and ultimately it held and reiterated the principle that accessibility is part of Article 14, 19, and 21, which is the golden triangle of Constitution of India. In a sense, what it said that without accessibility, people with disabilities are not able to enjoy their socio-economical rights, political rights, civil rights, cultural rights, and so on and so forth. Their inability to live in a community life because of lack of accessibility becomes a problem, as in when they are not able to get equal exposure to all the facets of life. And the NALSA report brilliantly touches upon various rights of how, due to inaccessibility, these rights gets impacted. Be it your social life, be it your intimate relationships, be it your health care, and so on and so forth. From that perspective, this judgment essentially very clearly states that accessibility is ex ante duty of the state, and reasonable accommodation is ex nunc. What that means is, accessibility, when this judgment talks about, it refers from the lens of universal design perspective. And I'll go back to what ma'am said, is basically you design your products, services, and environments for everyone, which everyone can use without the need for adaptation, which includes persons with disabilities. There's a fundamental difference in saying that you design something which persons with disabilities are able to use versus you design something which everybody, including persons with disabilities, is able to use. What that does essentially is it shifts the approach from disability to person, right? It shifts your approach to look at persons with disabilities as persons first, then persons with disabilities later. In that sense, it recognizes the right of the principle of universal design and lays down that in order to achieve substantive equality, accessibility is a precondition. It also very beautifully lays down a fact that accessibility, or the norms for accessibility, cannot be laid down just by having aspirational ceiling and not having minimum floor, which is why it says that the Rule 15 of the Rights of Persons with Disabilities rules, which basically laid down various standards of accessibility, although did have aspirational ceiling, but did not have non-negotiables, i.e. the minimum floor basis which accessibility can be ensured. Hence, it was struck down for being badly delegated legislation. The another important discourse that this judgment allows us to do is the differentiation between accessibility and reasonable accommodation. Accessibility, as I mentioned earlier, is an ex ante duty, which means that the state needs to provide for it even before an individual request is made. The state needs to be proactive about provision of accessibility into its products, services, and environments. Reasonable accommodation, on the other hand, comes into picture where, despite taking the measures for accessibility, if a needs of a particular individual cannot be met out, in that case, reasonable accommodation kicks in as a principle, again, with an objective to provide substantive equality. So from that perspective, this judgment actually lays down very important principles, not just from persons with disabilities perspective, but if we look at it, then for any group which needs constitutional protection in its true sense, then they will, for their fundamental rights to be upheld, the duties that are imposed upon the states or the private players and alike will have to be kind of followed or fulfilled to be able to ensure that the persons are able to enjoy their fundamental rights along with others, at par with others. That's the main principle, in my view, this judgment really lays down. Thank you.
Okay, I could again want to sort of add on a couple of more things to what Amar has said. It's true that reasonable accommodation, the very fact that the principle of reasonable accommodation, and I think at least people at NALSA would be aware of, that we have not restricted the application of principle of reasonable accommodation to persons with disabilities alone. It primarily comes from this particular insight that one size doesn't fit all. You try to make for as capacious a size, you try to make it in a manner where as many people as can come in would come in, but you may still require some level of customization, and that customization is what we're speaking about in terms of reasonable accommodation. So the consequence should be that no one is left out. The other very significant part of this judgment is that it is looking at, or it's articulating, the right to equality and inclusion as a constitutional principle and not just an application of what the statute has provided for. So the statute has recognized 21 impairments, but the judgment is recognizing more. Ichthyosis doesn't figure in any statute, nor does, nor is the sickle cell disease explicitly provided for in the statute. But when it comes to the judgment is very clearly saying that if the consequence is exclusion, then you have to bring them in. And it's that articulation of equality, I think, that where you're making inclusion as the other outcome should be equal as the driving force of the judgment is something that we need to look at. Again, I'm saying that if you do not restrict yourself to seeing reasonable accommodation as only something people with disabilities need, but recognize the fact that all rulemaking or all defining, if it gets some people in, it leaves a fair number of people out. And if it leaves them out, and the manner in which you look at that interpretation, if you start to sort of fine tune it and say that if we have to reasonably accommodate to ensure that nobody is excluded, but inclusion is the fair outcome, then the judgment is giving us the possibilities to do so. Our third speaker on the panel is possibly, it's like we had last year in the same Courts and Constitution, we had a panel around the Supreme judgment. We had an entire conversation on what the court had done in relation to the right to marry and where all, possibly they copped out and all of the kinds, and what was a sense of disappointment which came in. And I think different people have been reflecting upon how do you get the court to revisit Supriyo? What is it that needs to be done for us to think in terms of the whole question of relationships and, on both your own, the relationships you create yourself, the entire privacy question, and at the same time, a certain level of social recognition. How do you work that triad together, that combination together? And I somewhere feel that, again, on this particular aspect, this judgment has opened up a window, or at least has opened, it's kind of like, I think, put that totally shut door hasn't been some way opened. How it has happened and what's happening there is what our third speaker, Abhishek Anika, is going to speak on. Abhishek Anika, of course, figures in the judgment. He's been with misspelled, but he's there. And I think all of you who were there for his book talk the other day know Abhishek, so I don't have to introduce you now. Go ahead, Abhishek.
Thank you, Professor Dhanda. The thing is, to be here actually is a little surprising because I never take myself seriously as a disability rights activist. because my way of thinking is always antithetical to the way generally disabled. I'm optimistically pessimist about everything. So it doesn't work out for me. But then what happened is that Professor Dhanda, in her spirit, insisted that I write a testimonial, and it should start with the acknowledgement and where Nalsar report and including what I wrote figures in the judgment. And that is, in the judgment, it says right to form relationships. The report highlights the emotional and relational challenges faced by PWDs, particularly regarding access to love, desire, and intimacy. Abhishek Aneka, a disability rights activist, emphasized that disabled life is often lonely and alienating, with public discourse on accessibility ignoring private, intimate needs like access to sex and relationships. Emotional needs such as privacy and self-pleasure are often overlooked, leaving disabled individuals, especially those living with families without private spaces, to express these needs. Now, not only this is a historic thing for the courts and for Nalsar or for any of us involved, but it is constitutionally a very important thing which has happened. The court recognizes something which I don't think it has recognized enough, which is desire, self-pleasure, and privacy in that context. Because in our country, when we start a conversation about desire, it generally ends up badly. It has negative connotations. It is about consent or not consent and things like that. There's never an aspect to the conversations of desire which is essential to the idea of desire itself, which is pleasure, the idea of pleasure, and that the body and the self experiences while positioning themselves in a society, which all of us do. And sometimes it's easy to forget that within the frameworks of law and within the frameworks of society, that this is not an equal, the right to desire is not an equal right. And it is not an equal right because our right to desire and to express them freely depends on our social positioning. It depends on our caste, it depends on our gender, and it definitely depends on our disability. So when people who have disabilities and ranging from even disabilities which are invisible, which they can't be talked about, which is one of the most important things about the Rastogi judgment, I think, because, I am not, you look at me and you look at a person with locomotor disability, but that's not even half the case. I'm a person born with Vater syndrome. It's a rare disorder and later deteriorated into different kinds of locomotor disability, but my essential disability is invisible to you, which is chronic UTI and things like that. And that hasn't been acknowledged. So if primarily what I think of myself is a disability, which is chronic UTI, and I go to the government and say, my access need is basically finding a bathroom nearby, which is accessible. Or when I apply for a PhD program, I want a room with a attached bathroom. I did this with an institute. They said, why do you need an attached bathroom? I said, because it's my basic access needs. But because my locomotor disability doesn't translate into this murky sort of, access need, it is often ignored. Or a simple thing for me sitting in this chair and saying the chair should be better. This is my basic access need. I don't care about stairs. I can climb these stairs, but my chair should be comfortable. But because my disability, that aspect of it is not acknowledged in the law, the access part is also not acknowledged. So here's what Rastogi does is opens the idea of accessibility beyond disability, beyond the 21 disabilities. And anyways, it needs to expand in the coming years. If anything, as a disability rights activist, I believe that a disability, the idea of, and Professor Dhanda has reaffirmed my belief again and again, that even if you don't fit into the idea of 40% benchmark disability, you should get the dignity you deserve as a disabled person, even if it's 10%, if it causes discomfort to you, if it causes discrimination, because our laws are very our entire law is based on a very medicalized format. Anyways, coming back to the idea of what does it mean to have sexual agency, is a big question, and I don't think there's been enough conversation in our country about it. When I read about sexual citizenship, it's often in the Western context. For example, in Netherlands, disabled people are paid a sum of money every month, and although it is not explicitly for sexual purposes, it is assumed that it might be used for sexual purposes, and everyone is comfortable with that discourse because there is already an acknowledgement that disabled people have sexual desires. But in our country, the entire idea has been desexualization of disabled people. And so just to come out and acknowledge this idea that disabled people are sexual, they have desires, they want self-pleasure, they might even want sex, and which is the most interesting part, because then we go into the question of the idea of right to sexual citizenship, right to access to sex, sex work. Sex work becomes a very important question. In other countries, the research, what they showed that disabled people, in fact, there's a paper by Lydiard which shows clearly that disabled people, when they go around trying to buy sex, they are actually not looking for sex. They're looking for validation of their identity as men. To fit into that hegemonic idea of men, they are going out and looking to buy sex, or they are trying to gain some experience. So when they go to the dating market, they have at least know what sex is about. This is a conversation which is completely missing till now in our country. And I think it is time to focus to bring that into spotlight, because eventually disabled people live, a lot of disabled people lead very alienating lives. And people who are severely disabled are often deprived of self-pleasure because they live in their homes. Most disabled people live in their homes. The primary caregivers are their parents. It's impossible to have conversations about masturbation, which is, and the scope of the judgment is actually, something which Professor Danda sent me a few days ago is Madras High Court has a judgment where they have mentioned this part of Raturi judgment in context of a judgment about whether a straight able-bodied woman can masturbate while being in a marriage, and this is very important because this is something that probably even the writers of the judgment didn't realize, because the idea of self-pleasure, privacy, is never acknowledged even in the heteronormative context of marriage. So something which, and probably this judgment acknowledges that because it also acknowledges that disabled people probably can't fit into that heteronormative reality, and which is again very interesting because patriarchy reinforces the idea that people have to marry disabled people and that is the only way it's going to work. And this judgment itself, by acknowledging the ideas, it's somehow challenges heteronormative ideals of how a disabled person is supposed to contribute to the society. So in a way, all of these concepts, the concepts of self-pleasure, the concept of desire, the concept of intimate needs, will eventually be extended to not only all marginalized communities, but every person who requires that. When someone goes to court with that kind of an issue, this can be brought up and this will be brought up, and which is, I think, a very good step towards having a discussion on sex, sexuality, self-pleasure, desire, because as a society, while there's a generation which is exposed to these ideas every day on Instagram, we are a society but our laws haven't caught up with the ideas of situationships. They are now, every day the judgment comes where situationship, what do you think about situationship, which is interesting because, but these
ideals need to be also ingrained within the idea of lawmaking. The idea that despite not getting a judgment, personal opinion, that the judgment, the recent judgment about 377 and right to marriage said very nice things about queer people, although it turned into nothing, but it said nice things about queer people. And it acknowledged a lot of things which were not acknowledged before openly. And that, I think, is a great step ahead, because we need to have conversations. Right now, I live in Patna, a small, Patna, Bihar. So for people who see me as this don't see my personhood. The idea of personhood is still alien when it comes to disabled people. They see me as a disabled person. The state sees me as a beneficiary. A beneficiary is never going to be seen as a personhood, as a complete person who has desires, who wants to have a life, who wants to live independently or whatever. Whatever the conditions of life are never considered seriously, because I am reduced to the identity of a beneficiary by the state. And by just acknowledging all of these things, I think I can say that I can be more than a beneficiary. Because in this context, I'm not a beneficiary. I can't be a beneficiary demanding sex. I can't be a beneficiary demanding right to self-pleasure or things like that. And access, by the way, is important to all of this, because it's about access to spaces, access to places. For example, dating. Most of the dating apps are inaccessible. Most of the Rapido was recently fined, said that the High Court said they would take off the Rapido app if they were not accessible enough. So imagine a disabled person, young disabled person in their 20s trying to date in a city. The app doesn't work. The vehicle app doesn't work. The places they go to, they have to be very particular about accessibility, because all the places are not accessible. And then imagine the idea of being desexualized after all that. So these are three things which you have to consider. And in today's age, this is criminal, because for most of the other heteronormative, able-bodied people, it's the rule. It's life, day-to-day life. So against all this backdrop, it's essential that we have to expand the idea of personhood. And I think this judgment does that in a way that has never been done before. And that will be the basis of further expansion of rights, not only for the acknowledged disabled people, but there are many unacknowledged disabled people, and many disabled people, quote unquote, old people, who don't want to embrace disability because there is a lot of disability phobia in it, but they use everything which is meant for disabled people. And so I think this has given us a chance to think again about, a society, for the able-bodied society, to think again about disability and how important it is for them to think about disability and different aspects of it, because sooner than later, it will intersect with their lives. Thank you.
Okay, so naturally, because I've been adding on to everybody who's spoken before, I can't discriminate against you, no, Abhishek. I don't know. I mean, the way I went and read the judgment again yesterday, because that's basic practice, I think, for a teacher, that when you have to do something, you have to prepare. So when I read the judgment again, I sort of found that this one paragraph where they are quoting from your affidavit is primarily coming as that the report says this. And then they have taken the paragraph as is. But what is very significant, as I kept thinking about it, I said, okay, fine, they are saying the report says this, but it is significant that they have chosen this paragraph. It is significant that this paragraph is part of the judgment. And you tie this up with the fact of their firstly speaking in terms of accessibility being made for all, including people with disabilities, their emphasis on equality and saying and recognizing that accessibility is a cross-cutting right. It means if you don't have accessibility, you don't have these other rights. And then to sort of in talking about the other rights, to speak in terms of the importance of personal relationships and to say that for you to be a full person and an interacting person in society, you need to acknowledge the reality of desire, privacy, self-pleasure, and I'm just wanting to, I was having this conversation with Abhishek this morning, and for me, it is kind of quite telling that there is almost a matter-of-factness with which this has been acknowledged for people with disabilities. And if you compare that with the heavy lifting that they were doing in Supreme, wherein the court was sort of wiggling all rounds in somehow the other to say, okay, if not this, then at least that kind of discrimination, at least no kind of violent conduct. And you believe that everybody else has a say in terms of whether or not people whose choices are other than heteronormative, whether those choices would be permitted or not permitted. And an entire 5-judge bench is kind of sitting there and agonizing on it. And the matter-of-factness with which, for people with disabilities, I am not saying it is like they are quoting from the report, but they are quoting from the report. They didn't have to do it. And they are quoting from the report, fully acknowledging your affidavit. And I think that's significant. It's something which needs to be built upon. The other point I want to make, and I suppose this is the purpose of this panel, it's important to appreciate that they gave much more easily to people with disabilities what they were not willing to give to other excluded groups. So if that is the case, then possibly an engagement with disability rights doesn't just benefit people with disabilities, it benefits all. Because you may find that they may just be the Trojan horses. I understand the Trojan horse story is a little different than what is put out usually, but they could well be the people who could breach the sort of barrier that we are all confronted with. We think of only people with disabilities, like facing impediments, or people who kind of are all of the time in this obstacle race. It might be worth thinking whether disability rights and jurisprudence can actually flatten out obstacles which may otherwise you feel are there all of the time. It could be. I mean, I'm willing to admit the fact that the court may have done it out of the goodness of its heart, because they are good people and we are kind people and we have to be good to people with disabilities. Poor things, as it is, they have such a difficult life, so we shouldn't be making it more difficult. But who cares? Who cares what is the reason for? That judgment is in that particular paragraph, is in black and white in that judgment. How we wish to interpret it is with us. And I'm only sort of saying is that if we do not take that opportunity, then in some way we are missing out that which has been given on a platter to us. The last part of what we want to discuss as part of this panel, and which I have taken charge of, is this whole question of participative lawmaking. See, we have participative lawmaking. We talk in terms of the NOCs that you have to obtain, under the Forest Rights Act, that if you're wanting to clear a forest right, then the Gram Sabha has to give you an NOC. We speak in terms of people participative, also in terms of, sometimes certain rules and regulations have to be notified as drafts. People have to make representations for about 60 odd days, and then they are re-notified only after that, taking into account what people have said. Generally, our experience in that entire thing has been, कि नाम के वास्ते करते हैं. It is very symbolic. And for the experience in relation to Gram Sabha's NOCs, we have any number of tales of where it was either not notified or notified at a time when nobody came to know about it, or you just hurried and hassled people through it and all of that. I wanted to tell you a different story, and that's exactly what I feel is the story of Rajiv Rastogi. See, the case was filed in 2005. Rajiv Rastogi is a blind person who sort of started this entire conversation in the old act, the 1995 Act, saying that the statute is providing for these kind of accessibility rights. What have you done? You please tell us. And the court kept passing, like notices after notices, asking states to report, doing a whole range of things. In 2017, you had, after the new act had also come, you had a judgment from Justice Sikri, where he very clearly sort of put out, okay, this is what you need to do. We want a report. This is the manner in which we want that information to come. and not very much success even in that situation. Because like Raturi was talking the other day, and he said, we spent more time in just trying to unravel the affidavits and trying to understand what is happening there. It's in that scenario where they felt that they were not making too much of headway in trying to even understand what the accessibility situation in the country is, that it was proposed to the court and accepted that let's get an independent agency to assess the accessibility status of the accessibility status in the country. And that's wherein they kind of decided to ask CDS Nalsar to do it. And this particular order came in November, because I wasn't in the country. By the time we sent in our acceptance, we did a back and forth. It was January of 2024. And instead of gave in the acceptance and said, okay, we will do it in 6 months. We'd also asked questions around, okay, but we are a small center. From where are you going to expect us to get resources? And I said, fine, that, like the Ministry of Social Justice will reimburse you for whatever expenses you incur. And our thing somewhere was that, okay, keeping the norms or principles of public frugality, we will operate on that basis. That was the understanding between the court and us. And we had said on about 13th or so of January that it will take exactly 6 months to submit the report. The report that we made was not done by CDS Nalsar alone. It was done by, of course, we wrote to the states, we wrote to the center, we told them to, we gave them a basic template and format and said, you please report back to us. We heard from 14 states, we heard from the center, we got some information even because we'd written to prisons all over the country, and we got information from some, we didn't get information from others. So the one way of sourcing information was all the state entities should be asked to tell us what has happened. The other way was that we had civil society organizations through the length and breadth of the country to underscore to the court that this is a cross-cutting right. You don't give accessibility, you don't deny accessibility alone, you deny everything else. So you had people doing a study in relation to education, employment, transportation, leisure, culture, sport, the whole business of courts and accessibility. And these were studies which were carried out by civil society organizations across the country. I mean, it's a large number. If you look at the report itself, it had some 100+ organizations who were involved in the whole process. You recognize the fact that accessibility is not an issue only of some impairments, but you largely think about accessibility as an issue with locomotor disability, with blind people, to some extent with hearing impaired, and then period. Most other impairments, what are their accessibility requirements is not even known. And because it's not known, you don't have any kind of discourse. So what we did there was we had affidavits being filed by people with disabilities, people with autism, people with intellectual disability, people with sickle cell disease, people with person with ichthyosis. And it was in that connection, because this whole question of, if it is impacting all right, it's also impacting your rights to, sexual agency. And that's where then Abhishek was requested to give us his affidavit, because I felt I needed somebody who could do it strongly. We also had, people from our own university who spoke in terms of giving an affidavit for temporary disability, that what happens if you were disabled and you became okay, you're somewhere in no person's land. So this was the manner in which that entire discourse was presented to the court. And I find it's important to say, we had said we'll take 6 months. We submitted the report one day before the 6 months were over, because for us, it was extremely important that we should not ask for more time. And more importantly, also, we told the court that, yes, you had given us the opportunity to sort of seek resources or seek reimbursement from the government, but we have chosen not to do so. So this is a people's report we are submitting to you. And it's a people's creation of, and the entire vision of what we think should happen here is something which is coming in from what is the lived experience of the people, the primary stakeholders, but others who may not have been defined and included within the Disability Act, but accessibility impacts on them also. See, The court then, when it came with its, I mean, because others have spoken about it, I don't want to repeat that. I'm wanting to just focus more on the people participation part of it. But one particular dimension was that, like what Amar had said, that the rules which we had in place were rules which were primarily aspirational. The statute said you shall sort of put down exactly what people have to do to make the, whether it's a built environment, whether it's transport, to make it accessible. But the rules, instead of putting down the non-negotiable standards, said this shall be followed, but everything which came from there was guidelines. So the center kind of emphasized on the fact that, listen, if you are giving a right, and to realize that right, you are not putting out what is like what Chandrachud says in his judgment, to have a ceiling without a floor is an unstable structure. Because you've not put a minimum mandatory, you need to create a minimum mandatory. And so they said, whatever your Accessibility India campaigns and other things you're doing, you continue to do, but you must create that floor. And what is critical for my presentation is that they're saying that you must create that floor in consultation with the stakeholder and involving Center for Disability Studies. So that was the ruling which came from the court. They were insisting that the ministry is not going to make these rules on its own. They are going to make it in consultation with the stakeholders. And I suppose in some recognition of the work we had put in, they wanted CDS to be involved. What I find, and this is something which is after the judgment, and that I also want to share with you that, okay, the judgment came, this pronouncement came. So what is it that happened subsequent to that? As the Center for Disability Studies, we wrote to the ministry and said, this is what the court has asked us to do, and we are here available for you. Tell us what you want us to do there. Before that, we had done one, an explainer, and two, looking forward with the entire civil society, telling them exactly what has been ruled by the court and how we can move forward. So we prepared the ground with the stakeholders before we spoke to the ministry. After we spoke to the ministry, then there was, I think at least it's, to the best of my knowledge, I do not know of an earlier precedent or another set of group. And that's why I'm sharing. So what we did is that we floated an online form, because the ministry was as such kind of ready of creating a committee of experts and saying, okay, we're going to go ahead and, formulate these mandatory rules because the court requires us to do it. So we wrote to them and say, you just can't go and formulate mandatory rules. You have to do it in consultation with the stakeholders. That's a very integral part of what you have to do. So the process is as important as the outcome. So we had an online form being floated. The online form was floated in the name of the Ministry of Department of Disabilities, Ministry of Social Justice, and Center for Disability Studies, Nalsar, inviting people, listen, we changed the entire things and saying this is kind of crazy that you're going to make one set of rules for ports, another set of rules for rural development, something else for aviation, something else. So it doesn't make any sense. A toilet anywhere is a toilet. A ramp anywhere is a ramp. So you need to make rules in relation to built environment, transportation, products, assisted devices, and services. So that is the way in which the entire work got divided. So we had 6 thematic areas. We invited people. It was not nomination. It was asking people to say, how can you presume that people have the time? You need to ask them whether they have the time or not. That's a more respectful way. Ask them how much time they can give. On that basis, you constitute your core committees. So the core committees, the civil society core committees, were constituted on the strength of people applying for what they wanted to do, where did they have the expertise, and how much time could they give. Depending upon, if people gave 15 hours or more a week, they became a part of the core committee, but everybody else who was giving lesser time became part of the extended community. So you had the core committee, you had the extended community, and you had the world at large. So the point somewhere basically was that the core committee people will sit and do the nuts and bolts thing, but the people who are in the extended community will feed into it, and the larger body has also to be kept in the loop, because you can't think in terms of this as an elitist enterprise. Now, this part of the story, you would still say we've had further experiences when we made the law, when we did the country report, that kind of interaction with civil society we've done before. What is unprecedented is the ministry then wrote to all the other relevant ministries of the government of India and said, you nominate people who have to be a part of this group of built environment. So your Ministry of Urban Affairs and Housing and Urban Affairs, I mean, I'm just giving as example, or like the Civil Aviation Ministry, or the railways, for transportation, or the factor of who is involved in the doing of buses, who is kind of, you need to get the ISI people. If you have all of these other ministry nominations, and the process of making rules is happening with the ministries and civil society organizations sitting together and trying to work out exactly what the rules, which is going to be the mandatory rules, have to be. This is where the story is at the moment. We've kind of, at least for some of the thematic areas, we're nearly there. For others, it's a bigger struggle because the work is more complicated. So both for civil society organizations as well as for the government, it's an education to realize that it's not as simple as all that. And it also makes for more responsible critique from civil society organizations, because when you're sitting in that seat and then you have to devise, you understand that why it is difficult and what all has to be done. On the other side, to get commitments from other ministries and say, listen, you give us an undertaking that if you are agreeing to these rules, you will implement them. And these are the things that you have to do. The reason why we want participative lawmaking. So, I mean, I felt this should be shared. Participative lawmaking is not something unique to people with disabilities. It's not I think every concerned stakeholder wants that they should have, their voice should be heard, what they require should be talked of. It has worked to a great extent for people with disabilities. Again, like I said, it could well be because people find it more difficult to be mean. It's not like you don't encounter, yeah, that's it. It's not like you don't encounter meanness, but you find it difficult to be mean. But I'm saying is, if that difficulty to be mean or the necessity to be kind, I would see it as a resource. It's like, as a woman all my life, it would be like, okay, fine, you want to be nice to me because I'm a woman, go ahead. You try to be, otherwise I'll tell you. I mean, it works for me both ways. I mean, it's like, if it is like, out of chivalry, you want to do it, who cares, so long as I get what I'm wanting. I'm sort of seeing it in a very similar sort of way for people with disabilities. I am somewhere thinking that the model for participative lawmaking, and you could say, like, I think my student Shashank was saying, they're really democratizing the Constitution. It's like how, if you are talking in terms of democracy, then exactly what all do you need to do, and that it's possible to do it. See, I had this piece that somebody sent to me from a person called Shruti Pushkarna, who was talking in the context of Trump and the way in which he's been battering diversity and disability and saying, my God, this is like very scary. This is the sort of thing, it's like beating the drum beats for exclusion. And as I was reading her piece, it's not like one didn't understand where she was coming from. But I also sort of somewhere felt, and I'm sharing this with you, maybe that's my way of looking at things. I feel when people behave very badly, they shouldn't be engaged with, they deserve to be ignored. When you engage with them, you give a respectability to what they're doing, and I don't think that they deserve it. That's my personal opinion. I'm not saying that he won't be doing. I somehow the other feel it's important at that time to up the ante of inclusion and to start talking about what is it that inclusion can do, which exclusion will never be able to do. When you may be engaging with them in the sense of you're giving them these side halves, but I genuinely think to give them the respectability of dialogue is not something that is required. So it's in that context with so many of us, and we're all encountering a lot of unilateral lawmaking, a lot of rules that are being made without so much as by your leave. In that scenario, it's important to see what happened in Rajiv Ratturi, what's happening in that rulemaking thing, which is allowing for this constitution or the entitlements of the constitution to become a greater reality, a reality we are driving ourselves. So thank you so much. And wow, I'm impressed with myself. I have at the dot stopped. So exactly the half an hour which I'd kept aside for the floor discussion, because I'm a great believer that you can't call, even if people are coming on mandatory attendance, you can't call people and then not talk with them. So I'm throwing it open to you, questions, concerns, clarifications, disagreements, everything. Go ahead.
Am I audible? I'll stand up here. I hope I'm visible and audible now. The RPD Act has changed the nature of disability legislation from one which sees it as purely medical or welfare to one which envisages it broadly in a human rights perspective. This has been envisaged and furthered in progressive judgments like Rajiv Rature. However, we still find that the enforcement is a problem, and the rules which are supposed to be positive enforceable rights have also not been framed. In light of this, what do you think would be the primary challenges once the rules are framed? And is there a broader mindset change that is required to, further disability rights? This question is open to the entire panel.
Well, for any law to be effective, the implementation mechanisms need to be strengthened. And India is one such country where unless your implementation and monitoring mechanisms are not strong, the implementation of law becomes challenge due to various reasons. I'm not saying that we are bad at complying law. It could be lack of awareness, lack of intentions, lack of guiding principles, etc., and many other factors. So in this light, one of the real reasons, as you rightly pointed out, until now in the disability law was that the implementation mechanism for enforcement of law, imposition of consequences was really unclear. So with this rule making process, especially around accessibility, I'm pretty sure that, the challenges that we have had so far around imposition of penalties or occupation not being allowed or completion certificate not being given or building plan not being approved, etc., which were lacking right now until now, will be taken care. So that's, and I think mindset change comes when you have built a culture to make that happen. Why people don't understand accessibility or needs of persons with disabilities so much so as of now is because, for instance, people with disabilities are often seen as, not being able to do X, Y, Z, or being dependent on many things for others, right? Why is it the case? It's the case because we don't have accessible infrastructure. We don't have equal opportunities. Once you have that in place and once you see people with disabilities performing and doing what they can do their best and contributing, I think this mindset will change through that. And for that to happen, the enforcement and monitoring mechanism needs to be very, very strong.
There's too much symbolism and very little real intent in how society sees disabled people as well as how state sees. And that is the root of the problem. Because as Professor Arat said, they're good to us in public. What happens when there is no public eye to look at the way able-bodied society treats disabled people, and it's quite bad. And the government just imitates that. While it can rename us Divyangs, it can also do what there is every year the allotment for enforcement of RPD law becomes lesser and even the money which is allocated isn't spent. And that is a basic thing which tells you about the real intent of the policy establishment. And because if the real intent is to actually do good, then and everything you can imagine accessibility wise comes under enforcement of RPD law. It can come under. So there is a law, there is a division, there is a ministry, there is a department, everything is there. There is no intention to do that. So I think, and society is the same, more or less. It's changing, but The changes, people are still there's deep rooted stigma against disability. You know, like I am as an educated person know that there are people around me who think if they are having a child, they won't call me over because some upshakun ho jayega, which is like the most bizarre thing you can expect someone who is convent educated. Like all of these people who are professional and proper. But that is the hypocrisy which is in the society, and it's reflected in the. So until that changes, that will take a long time.
I think there is this whole catch-22 situation. People with disabilities are not visible. That's why, I mean, you know, a lot of things, the law policy is not really looking at them in a way. And that's why we say that, you know, inclusion should happen right from the beginning, so that everybody kind of, you know, is aware of disability. What Amar was speaking, that culture automatically comes. I mean, as a person with disabilities, wherever I am being involved, I mean, you know, I've seen basic small changes happening, because suddenly people do realize that, you know, he's there, we need to do something for him. And slowly, slowly things do kind of, you know, happen. I mean, not saying that everything happens, but that basic awareness starts creeping in. And there is this, I mean, a hypocrisy that Abhishek was speaking. There's another thing. People are, I mean, you know, scared to kind of say that they are disabled or, I mean, you know, have disability in the family. But at the same time, they are willing to take all the benefits that come through disability. I mean, you know, you will find a lot of people who would want to take it. In fact, while I was working with National Trust, they had come up with this insurance policy. I forget the name of the policy. But you know, they found that there were so many people who actually suddenly became disabled and took their money. I mean, you know, especially in the northern states. Ultimately, they had to shut that entire insurance policy, and then it didn't work out. Yeah. So we have to kind of, you know, get away from that hypocrisy. I mean, you know, take benefits and then say, okay, I mean, I'm not disabled. You can't have both. You have to kind of, you know, be kind of, I mean, be very clear about disability. Thank you.
I would sort of, I would want to sort of answer your question in the light of my presentation and what I was tracking for you. I'm not trying to paint some rosy picture, but I definitely do think that when you are on an everyday basis getting people who are meant to be implementers to sort of, you know, to participate in the rulemaking in an informed manner, not as just a knee-jerk thing that you have to somehow make do with something. I'm not saying that these changes come overnight, but I also do think just to get the ministry used to the fact, just to get the other ministries used to the fact that you can't hold a meeting without calling the concerned stakeholders, that there has to be a sign language interpreter over there, that there has to be, you know, like captioning, which has to be available. They're very small, small things, but you are recognizing people to operate with the presence of disability. Not something that you have to just do and I think this is it's a known thing somewhere that you need to. I remember long years ago, you know, like I used to, when I teach that course in jurisprudence, so had this entire business of the importance of thank you notes. You know, you have a party, you meet somebody, someone gives you something and you write a thank you note. And then you suddenly have this saying, "Arey nahi, mehsoos hota hai na, kehne ki kya zarurat hai?" So the point somewhere is being that no, you have to keep saying you are grateful, so that over a point of you're continually saying it, you start to feel gratitude. So my issue somewhere is this, that when we are talking in terms of implementation of laws, the rules are not going to make the law, going to make it a reality. And they're not self-regulating. They're not self-executing. Somebody has to see to it that it gets done. For that to happen, it's important that you start changing, altering. I don't want to say mindsets, and I really want to say that, you know, you want to change bureaucratic cultures. You want to change everyday relationships. And that requires a lot of, you know, a lot of doing. You keep making people do something. If you make them do that every time they forget to call the sign language interpreter and somebody is making a ruckus over there, it starts getting hardwired into the person who's organizing the meeting. That I can't organize a meeting without a sign language interpreter. I can't organize this and that and the other without finding out whether the venue is accessible. You have to change the wider ecology. And that, not only, I'm not talking in terms of taking time, I'm saying that's what this entire enterprise of rulemaking is. It's not what we get at the end of the day, but it's a fact that it's being done in this kind of participative manner. People who are in charge are being told this impacts on people's lives, and they are telling you how it impacts on people's lives. We are largely much better when you remember, meri cousin, mera fala, mera this ka something ko kuch ho raha hai. When it's just to talk about generically for people with disabilities, we don't feel the same way. That's the way I would answer your question. I'm not sort of being gung-ho about it. I am definitely sort of not, maybe because I am the semi-disabled person on the panel, like I sort of stand on both sides. So I always say I'm in the land of the gray, somewhere both a person with disability and not. So I speak from there. Yeah.
Sorry. Thank you for the presentation. It was really interesting to see how closely the CDS is working with the government ministries. But we have to understand that this is happening in response to a Supreme Court order. And like your presentation focused, Professor Dhanda's presentation focused on this idea of collaborative democracy. So in that spirit, what kind of mechanisms can we put in place to ensure that this kind of a collaboration between the academia and the civil society and the government is happening without necessarily having the judiciary to intervene in every such instance? Yes, ma'am.
Okay, it's like this, Vishnu, the way I would see it is, I agree with you that we don't need, it should be happening without necessarily the Supreme Court intervening. When we did the law, the 2016 law, the law was born in Nalsar. It is after its many reincarnations, it came to 2016, but in 11-12, we did the law here. And we had the law being consulted through the length and breadth of the country. We sent it to the government. The government at some point decided to go gung-ho and do what it wanted to do, which was not what we had made. But because we had done that law in consultation with entire civil society organizations through the length and breadth of the country, we were able to get the entire disability community on the streets because we told them this is not the law that Nalsar consulted you with. And willy-nilly then, the law went to a parliamentary joint committee, and ultimately what has come in has brought back a lot of what was done in consultation with the relevant ministries and civil society organizations. The thing somewhere is, Vishnu, you have to show people it can be done. We can't begin from this factor of, when anybody like you learn how to skate or you learn how to do anything, you don't start, firstly, when you learn cycling, you have those side support things, no? You don't start off by saying, ki nahi, iske bina hi chalenge. So if the Supreme Court is triggering something or facilitating something well and good, at this point of time, the case was meant to be listed in the court on the 8th of March. It was listed, but it did not get taken up. We have a lawyer who will be kind of setting up the case for us, but we are all involved in the process of lawmaking, and we know that the work is happening on an everyday basis, but it's not completed because the court has just given an off-the-cuff 3 months deadline, not really realized how much time is to be taken. The work is happening. The court is not being in any way, we're not going back to the court and saying, ki kya? We're saying, okay, fine. We are working, the work will happen. We will not activate the court if evidently civil society and academic organizations and the government are at the job. We will only involve the court if at any point of time we find anybody flagging. So it's a strategic thing, you know. I mean, I wouldn't say कि अरे ये उनके साथ हो रहा है तो it is meaningless. उन्होंने करवाया है, they've triggered something for us. Now it's up to us how we're going to capitalize on it. And this business of, you know, like just the fact that we have a core committee and we have an extended committee and we have the wild world, we had made it an absolute article of faith for us that everything which is happening in that committee or what is happening has to be shared with everybody. We've met so many people in the making of those rules whom we did not know. We did not know they existed. We did not know there were people with that kind of expertise. And we've been able to get that in because the whole process started by an open form and asking people to apply. We've also very proactively brought in people who we know possess the expertise and say, "Nay, we need your inputs because it should be the best that we can do." So it's in that scenario, you know, you don't have to throw baby with bathwater. You use the court to the extent it is useful. But nobody is relying only on the court. But if the court can get some things to move, we won't have any hesitation to use them.
Hi, thank you so much for the presentations. They were really interesting, especially Mr. Anika's presentation on, you know, the right to intimacy and pleasure for persons with disabilities. Now, my question is with regards to making infrastructure accessible for all, especially in the context of employment. Now, given that India does not have a law that requires private employers to hire persons with disabilities and the costs that come with updating infrastructure, do you think that one of the perils of strict enforcement of these rules is that employers could perhaps be disincentivized altogether from employing persons with disabilities? Because this is something that happened with the Maternity Benefits Amendment Act as well, that when the maternity leave was increased to 26 weeks, along with an array of other benefits, a lot of the criticism came from the fact that because of the kind of costs that would be imposed on employers, they would be disincentivized from employing women altogether. So do you think from a policy perspective, in addition to having these rules, which are much needed, is there anything else in terms of state support that needs to be done to ensure that they're meaningfully implemented?
Add into that with respect to that obsession of law and society and institution with mind and efficiency in that respect. Well, for example, criminal law, you know, exempt someone from criminal liability if there is absence of mental faculty, what you call insanity. At the same time, equally, it ignores the bodily suffering, as you have seen in the case of Sai Baba, because it's obsession with mental, so much obsession with the element of mind or mens rea that we call in custodial institutions. In such situation, while this approach of participation of people with disability in the process of reformation is a new approach which actually address this problem, but how do we engage with such vast institutions in different aspects of life?
Couldn't get the latter half of your question.
While this participation is an indication that or a step in the right direction, because it makes them participate, which can bring things which are not within the imagination of institutions or law for centuries that is in force. I'm saying since it is so enrooted that what is social justice, maybe what is for disability right, maybe it is unsocial justice. The selfishness of society is, for example, at some circumstances, the existence of disability may be a resistance to the society or societal norms. It is so enrooted in that, in the mythology, in society, in institutions, in law. So how do you think the approach of participation can actually address this?
Okay, I would answer, see the point that you're making in relation to employment, there are two dimensions to it. One is, as far as public employment is concerned, of course, you have reservations and I think it's all. But you also have the whole question of that you talk in terms of that employment has to be made available by all. More importantly, the connection you're making between accessibility and employment. Your accessibility obligations have got nothing to do with whether or not you're hiring people with disabilities. And therein, there's a great clarity that every building which the public uses is a public building. It is not to do with the ownership of the building. It's to do with who accesses the building. So you have to anyway do it. I'm not, and you are also like, that whether it's in terms of, it's also the point which Amar had made earlier, that if you are going to think of people with disabilities as these helpless, incompetent people, I mean, the fellow sitting, all these persons sitting next to me, each one of them, which one of them looks like helpless and incompetent? It's what I'm trying to somewhere say to you, which is partly the answer to your question. It is easier to believe in your stereotype if you've never encountered reality. But if you've met people with disability, you're encountering them, you find that whether it is, whether it's sense of humor or whether it is plain meanness, they have as much of it as other people have. And it's a very important part of your, if we have to shed stereotypes, if we have to shed attitudes, if you have to change them, if you alter them, you have to have friends who have disabilities. And I think accessibility, these kind of events, like the other day, if you came for Abhishek's book reading event, could you be really saying that this is an author with disability who's speaking, or it's more like a guy who's really experienced distress and suffering and has survived and worked and knows how to do it? The kind of advice he has to give is for anybody who's having life problems and struggling with. And that's exactly what comes with, to sort of say what happens. I'll say this to you as a student here. We have a certain kind of paradigm of merit. We have a certain sort of set of parameters that one has to fulfill of, a certain criteria that you have to come true on for you to be considered merit, like a person full of merit. But we also know that there are so many things that you are good at, but if nobody is counting them or nobody is valuing them, then your goodness doesn't count, though you have it. The idea, I think, what disability brings, and I'm not romanticizing the condition, what it brings is primarily recognizing that we have a kind of, there's a variety in terms of mind and body. And this stereotype that we create, or this one size that we create, into which everybody has to fit, is harmful for everyone, not just for people with disabilities. People with disabilities are a magnified part of it. On the other hand, if people with disabilities come into the discourse, they open up, they make it capacious for everyone, including themselves. And that's the point one is trying to make. If you begin from the entire, that's why I'm saying if we start engaging with the Trumps of the world, then we don't see what the diversity brings to all of us, what plurality brings to all of us. What is it that happens? Whoever said that because I'm a person with disability, I want you to hang out with me all the time? I'm blessed, damn it, I need my own time. I need time to be with myself. And participation is not going to change mindsets, but participation is the first step towards changing them. It's only when you meet people and you know them that you start to think otherwise. I had this experience, with Rungta at one point of time. He used to introduce me all the time as saying, I went for a meeting with him for a blind person's conference in Pakistan. And it was like they had a post-lunch session, and in the post-lunch session, one by one, everybody went to sleep, and the speaker kept speaking because he couldn't see they were sleeping. And the next day, I realized when I had to speak, I could see they were sleeping. I found it difficult to speak, But it became like that, depending upon what the majority thing is, that if the majority was blind people, they had their own business, or they had their naps, they came back and things continued. But Rungta would introduce me to everybody as saying, sighted hain or achhi hain. It was like, if you're not, it's a question of that. It's not like only we have. The disabled world also sees the able world in a certain kind of a way. It's only we don't know about it. And I think The reason why I insisted on the changing the title of this panel and to saying this is what we will talk about, saying I don't want to talk about disability rights. I want to talk about what disability rights has to give to you and you don't even know it. Because if you start to see that, then you'll say that what is it that when you speak in terms of disability rights and you make that entire receptacle more capacious, it's going to help everyone. It's going to make us a more inclusive, compassionate, empathetic society. And I don't think that only benefits people with disabilities. I genuinely don't think, I think possibly because people with disabilities like Aniket, Abhishek says all the time, have become hardened because they've encountered so much of rejection. They know how to cope with it. It's we who kind of like shrivel up and die the first time we kind of encounter any kind of resistance. Possibly, if you want to learn how to resist, you want to learn how to stand for yourself, you want to learn, it may be worthwhile to have these conversations. I mean, every single development that we've outlined for you all as part of the Rajiv Rathore judgment, I'm quite certain that most people didn't know it. They only knew, aha, CDS ne report kiya, Supreme Court ne acknowledge kiya, wah, 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 very good, very good. Uske ilawa, really don't know what the judgment did. And because it is, you can't be a prophet in your own this thing, it was important that one should come back, you know, literally speaking, bring coals to Newcastle, ki bhai tumhare yahan hi bana hai, lekin you must know what happened. And if we are doing courts and constitution, it's important to be not only doing what the courts got wrong, but if they got it right somewhere, what is it that they got right and how can we build from it? That for me is the why I felt it was very important to have this panel and to talk about it. Because, see, we are law people. The ruling has come, a certain principled enunciation has come. Does it matter that it has come in a disability rights case or it has come in some other case? The fact that it's not come in, you know, like one core true blood constitutional law case, does it mean it's not a constitutional law principle? And if you're not saying it because the label is not right, then there's something wrong with how we are studying. I think that's what we wanted to set to at least, I'm openly saying, and I suppose I can shamelessly saying as being one of the senior most teachers here, it was to educate and saying, yaar, tum kya karte ho? सिर्फ वही पढ़ते हो जो तुमको लगता है कि हाँ ये कोर्स में है, जो कोर्स में नहीं है वो पढ़ते ही नहीं हो. And it's important somewhere. There is so many possibilities, especially those of you who've been so bothered by the Supreme judgment. I will say, go and read that paragraph in Rajiv Rathore and see how it can open up another way of attacking Supreme. It could just well be that possibility. Similarly, those of us who've been battling with civil, political and social economic rights, this kind of hybrid enunciation which has come in Rajiv Rathore, what we are, when we are speaking in terms of participative lawmaking, to actually see it function anywhere. Because I remember the high point for me when I was doing my thesis was when I suddenly encountered a judgment where somebody was making a petition in, before a ministry, I think, saying, give to us what you have given to disability. That for me is the way when you suddenly realize that, okay, these guys have gone and won some spurs, which maybe many of us need. We have exactly 1 minute. I think we've kind of exhausted each other. So thank you so very much. Thank you to the panel and thank you to an audience. If it was at least, I can say this much for all of you, you were there. Thank you so much. Thank you so much.
We will all, hello. We will also be having the valedictory session right now itself. So please, another 15 minutes. We'll end in 15 minutes.
Well, good evening, friends. So you had 2 long days. I'm not going to take too long. I'm still trying to get used to my new role. Not this role. I'm a new role in Nalsar. Last year, the same time, I was actually representing Ajim Premji University in the same conference as an institutional partner. And so I could quietly say, if someone says, we are thankful to Ajim Premji University, I'm gleefully listening and leaving it there. Now I have the onerous task of saying something as a closure to the conference, especially in the absence of both the registrar and the vice chancellor because of their preoccupations and festival time. What I want to quickly take 5 minutes or so, basically to recount, this is the 6th edition. I have been privileged to be part of all the 6 editions that happened in the Courts and Constitution Conference. And so I want to just say quickly what I see as something that the conference meant to me and in wider context as I see it. And also the kind of role played by different people. And I think it's important that I recount this as an idea that started with Vikram Raghavan coming and bringing some people together to think about a conference like this. And since then, I think it really contributed, in my view, to a set of debates. I mean, I know there are other organizations also working on the developments in constitutional law kind of thing. There are very interesting individual blogs that are there. Law and other things itself has been a long tradition of writing about constitutional issues as such. But this conference has been a platform for certain critical debates at a time that constitutional law has become very significantly important in the transitions that we are seeing in this country. So I would say there are 3 or 4 important things for me that Courts and Constitution Conference stood for. And I would certainly say this is a platform for great learning for students and faculty alike. And I see students learn on more than one front, not only that they take absolute interest and their energy runs the entire conference, but it is also a learning for them in terms of listening to a variety of personalities, both very senior as well as those who have done stupendous work, even though they are relatively young. And like I suppose we have seen panels today and yesterday. It is also, by the way, very interesting to me that Professor Amita is not here. We started with an equality panel this time, and we also ended, in my view, with an equality panel of a different kind. Right. So if you see the disability discussion is also an equality or equal opportunity conversation. And caste question, as we saw yesterday, was also an equal opportunity and equal protection case. So it's very good. Somehow things have come in that sense, though she said that being last is something also the crowd puller kind of a point that Professor made. I would say then it is also important for me that the conference made an effort to not remain within the 4 walls of NALSA. It has been made accessible, and I could see a number of my colleagues and those who contributed in the earlier editions keep texting me that they are following the webcast of the conference and so on. So I think it's been very good that we made it to go beyond the 4 walls of NALSA. And so I guess you can very well see, therefore, there is much to appreciate. It is a very timely kind of an intervention to think about public law more seriously and the kind of transitions and developments that are happening. But I've also been talking to friends who have been organizing, student friends as well as colleagues in this university. Being a disruptor that I am through and through my law school life, I have to think what seem to be not. There are things that we certainly hope that we could do better as we go. And I would certainly put one key point for me is the deliberative conceptualization, the deliberative democracy thing that you have seen on the disability law and the decision question. We don't need to do that level of heavy lifting, but within the university and within among the partners that the Courts and Constitution Conference could bring together so far, I think we need a lot more deliberative conceptualization. I already shared with them, and as we began, that was my first conversation that happened. I think we can do a lot more. I think it is happening, but in my view, I think my student friends will forgive me for saying this. It is relatively informal. So much depends on the individual's initiative. So much depends on how much you can push with the institution. Every time there is a bit of uncertainty. So can this be, can this not be, etc. I would say, having spent 6 years in this, we need to develop relative confidence where we are very clear what are all things that the institution is going to guarantee and what is the way the process has to be put in place, how we are making the decisions in the right way that we do. I think that those kinds of institutionalization points is what I'm putting as deliberative conceptualization sort of question. I think the second wish list for me is a longer shelf life for the conversation. I think the conversations are always exciting. I think the people who came contributed enormously. We all enjoy within this space. And also maybe there is a video archive, there is some kind of archiving that happens. But I think my feeling is that there is potential for this to have a longish shelf life in the constitutional law debates. And that would mean maybe some kind of other production we need to see beyond the videos, beyond the conversation at the moment, beyond what we see within the immediate context. What would that be? I would say it is all something, once again, we need to bring into deliberative conceptualization sort of point. I would also add, I think until last year, Ajim Premji University was a partner and I was very happy. Arun, Sudhir, all of us were part. Now everyone, as it happens, will move in life. And Sudhir became a vice chancellor in NLSIU and Arun followed him subsequently. And Arun might move somewhere else, we don't know. And I have moved to Nalsar for various reasons. So as a result, what happens is the repositioning of partners takes place. And I think law, other things, and Nalsar are here to stay. But we also, I think, should think more academic partners, more partners who could really contribute to both ideas as well as making it much bigger than what it has been. But I think so far what we have achieved is worth relishing. It is something that we need to be proud of. But at the same time, I think it is also a time for higher ambition and aspiration. I think that's where I think we need to think about Courts and Constitution as a permanent annual calendar event of Nalsar. And in doing so, how meaningfully can we make it a learning experience for all of us, students, faculty. I want to see more faculty colleagues being present. How to make it, I think, is a big thing. I suppose, let's see how we can systematize in such a way the calendar would not clash with other things. I think this time the committee had to wrestle with dates, other kinds of things. I think we should fix a date in such a way that others should feel, yeah, they need to block their calendars if they are interested to go there kind of scenario. I know it's a big ambition, but I think we should really work towards. So I really think there is many more people to thank. I'm going to ask the organizing committee leaders to do their first bit, and I will have the last word. Yeah, okay, please come.
Check. Good evening, everyone. On behalf of the Student Organizing Committee, I would like to thank all the panelists and students for participating and engaging with this conference. The conference sought to bring together voices from the bar, the academia, and the social movement circles to discuss the constitutional law developments that we have had over the past few years. We hope that this kind of a thematic discussion that we have had over the past few days has helped all of you think more critically about the Indian Constitution. The fundamental value addition of this conference that we aimed at is to equip the students here and outside with the constitutional culture of reading the law and approaching the law from different perspectives. This conference would not have been possible without the support of Professor Sitaramam Kakrala. Thank you so much, sir, for taking out time despite having such a hectic schedule, given that you had just joined Nalsar and had so many other things going on. We would like to thank the Vice Chancellor and the Registrar for their unconditional support to the Student Organizing Committee. Given that Azim Premji University was not involved this year, we are really grateful to have had all the institutional support that we needed from Nalsar University. And for that, I think we need to specially thank Vasanti ma'am for that. And last but not the least, we would also like to thank Professor Siddharth Chauhan for his role in making the conference what it is today.
Hi, good evening, everyone. It gives me immense pleasure to also present this vote of thanks along with my co-editors-in-chief, Vishnu and Sukrit. Continuing where Vishnu left off, We would also really like to express our gratitude to everyone at the Law and Other Things blog who have helped us in making this conference. Specifically, our founder, Vikram Raghavan, he was foundational in conceptualizing this conference and working with us right from October to come up with the concept note and the final sort of event that you saw in the last 2 days. We'd also like to thank all of our senior editors on the blog who gave their insights on the concept note. This is Alok Prasanna Kumar, Siddharth Raja, Nicholas Robinson, Douglas McDonald Norman, and of course, Dayar Singla, who is one of our alumnus who initiated and started Quotes in the Constitution way back in 2019. And for all of their insights in helping create this conference. We would also especially like to thank Alok Prasanna Kumar and Shutanjaya Bharadwaj, who apart from being senior editors, were also panelists in the last 2 days and for their insightful presentations. We all look forward to the rapturing reports that have been prepared over the last 2 years, which will be published on the LEOT website in the next couple of weeks. And all the discussion, hopefully, that this conference generates on these important constitutional topics that we've discussed. Thank you all. I now hand it over to Sukrut.
Thank you, Archita. Firstly, I'd like to thank the members of the organizing committee, without whom this conference would not have happened. The event management team, which has been working since December in creating the concept note, inviting the panelists, all of that. I would also like to thank the logistics and hospitality team who have been working tirelessly these last couple of weeks to make sure that the conference goes on smoothly. The rapturing team, whose reports hopefully we'll see soon, and the PR team, which has been covering this event to make sure that we get the spotlight that we deserve. And in addition to that, I'd just like to speak a little bit about the importance of this conference. I think in today's political climate, it becomes all the more important for us to safeguard these spaces where, we can discuss, deliberate, and ask uncomfortable questions. I think spaces for free speech, open discourse, and most importantly, dissent are rapidly shrinking. And as we see these developments every day around us, which fundamentally alter the constitutional imagination of our country, I think we should all consider it as a matter of immense privilege, honor, and responsibility, rather, that we host the Quotes in the Constitution conference every year. And I think by doing so, we as an institution sort of reaffirm our commitment to nurturing the space where everybody can come and have a safe space to ask these critical questions. And most importantly, I think, to scrutinize power critically. So thank you so much for being a part of this. And I think it's a lot more than a conference. So thank you so much for all of you. And I hope this conference happens on a much larger scale next year as well. So I'll give the mic again to Sitaram, sir. Thank you.
Thank you, Sukrut, to give me the last word. I'm sure all of you by now know fully well that law school is not just classroom, but much more outside the classroom as we learn. And I'm saying both teachers as well as students alike. As it is already acknowledged, we tried our best to get Siddharth Chauhan, who was really at the helm of affairs from the university side, from the first edition till the last one. Unfortunately, this is also kind of a period in which there are many people who plan many things, right? There's a long weekend. So he had some other kind of plans, so therefore I couldn't persuade him further. But we will bring him at some point, and hopefully we'll have an interaction with him as well on the rethinking and redesigning of the way that we are aspirationally looking at the next edition of this. So that's about Siddharth, but I want to say I don't know everyone in the group who coordinated by name, so I won't be able to say that much. Siddharth perhaps could have been, because he has been here and he knew everyone in a detailed way. But I want to acknowledge the work done by the student panel coordinators, all the 6 panels that were there yesterday and today. I think they have done extraordinary work. One, of course, working with faculty colleagues in terms of seeing, of course, finding out finally who should come, who should not, and also recognizing it is not going to be just whoever we want will always come kind of thing. So there is a lot of flux and all that they had to take, and I think they patiently did. They did an extraordinary work. So therefore, thank all of them. And I think the three, Sukrut, Vishnu, and sorry, I haven't touched that. So all three, I think you need to give the biggest hand because they have done a stupendous job. Without their energy, I don't think the committee as well as this event could be possible in the way it happened, right? So therefore, let's give a big hand once again and thank you for everyone taking part.
Hello. Guys, first and second years to the podium side, everyone else from the other door, we'll take attendance outside. Just requesting the OC members to stay back. We'll take some pictures after this. Thank you. The volunteering team as well, please stay back. We'll take a group picture.